Morning, everyone.
Good morning, Judge.
Morning, how are you?
Good.
There's only me and you, I can see.
I'm sure they're not too far behind.
Right. There they are. Hold on, we're trying to get our,
Judge, it's gonna be a minute for the monitors to come on in the courtroom. Just bear with us.
oh, okay. That's what Miss Strong was calling about. That's you, Miss Lewis? Yes.
Yes, it's me.
Good morning.
Good morning. You still can proceed without the monitors. It'll be coming on.
Okay, I actually don't have, I have some family in the courtroom, which is good. But I don't have any other person, so I'm pretty good to get started. All right, good morning, everyone. I'm Judge Regina Mincy, and this is our state all-purpose calendar for Tuesday, May the 2nd, 2023. Just want to remind everyone that this whole entire proceeding is being recorded and live streamed on YouTube, so govern yourselves accordingly. And obviously listen to your attorneys. Who do we have first? Mr. Dotis? Courtroom 2? Can you hear me? You just muted yourself. Okay, there you go. Can't, don't think they can hear me.
Can you hear me now?
You can now.
Beautiful. We're
All
gonna
right.
probation calendar, and this is gonna be position 1 and 2, Mr. Robert Jackson.
Hold on.
Mr. Jackson. So you
Hold for a second.
We'll go ahead and reset their paths and go forward. I'll let you address that. Can you mute yours?
All right, we have Mr. Jackson, positions 1 and 2.
That is correct, Your Honor.
All right. First case is 18 CR 8199Y. Robert Lewis Jackson Jr. Charged with 1 count of reckless driving, 2nd count of possession of open alcohol in container, and DUI under the influence less safe. Offense date June 19th, 2017. Second case 23 PV 000417. Robert Jackson again, probation violation. Offense date April 13th, 2023. Probation.
Yes, good morning, Your Honor.
Morning.
Which we did have Mr. Jackson, but we have this was sentenced to probation on January the 23rd of this year.
Oh, you have a different offense date?
Yes, Your Honor, we got January the 10th that he was sentenced with Judge Edie.
Oh, what do you have, Mr. Dotus?
That's the day it was sentenced. I believe the alleged event occurred back in 2017, though, if that's the day you're referring to. But he was sentenced on, it looks like, he pled nolo on January 10th of 2023 of this year.
Okay, okay. Those are just the original offense dates, probation.
Okay, yes, Your Honor. As of today, Mr. Jackson has not reported to our office. He had to pay a fine of $444.50, completes a risk reduction program, victim impact panel, clinical evaluation, and 40 hours of community service. His case has 8 months, 9 days remaining. We are asking to revoke because of this new charge he just got in March of criminal trespassing.
All right, Mr. Dotus.
Thank you, Your Honor. Regarding the criminal trespass, my client is residentially challenged. He was just looking for a warm place to stay. I've provided him with a resource sheet. I'm going to provide him with another copy to ensure that he has adequate places to stay so that that won't be an issue moving forward. Regarding his conditions, he was not clear that he needed to report. I've made it clear that he will, if this court gives him another opportunity, he will need to report immediately and get started on the conditions to pass probation. He did tell me that he has already completed the community service provision. He did that at Wendell Drive Food Bank. He does need to turn that paperwork in. And he was under the impression that he had the full year. Again, he was sentenced in January 10th, so minus that time, he understood that he had that time to complete all these conditions, but he's still planning on it. So, Your Honor, we're at the mercy of the court asking for another chance for Mr. Jackson. He's clear that if given another chance, he will need to immediately report to probation and immediately get started on all of these conditions so that probation sees that he's making a good effort attempt.
Okay. All right, I won't revoke him. I'll give you one more chance, Mr. Jackson. And use the services of your attorney's office to help you with some needs and resources that you may have. I'll give you this last chance to comply with the conditions of your sentence, or else you'll be back in Fulton County Jail, okay? All right.
Thank you, Your Honor. And I'll provide him with another piece of paper that also has probation's phone number and address. So I believe he won't have any issues.
Okay, all right, thank you. Who do we have next?
You done? Next, we have position 5 and 6, Mr. Derek Pass.
Your Honor, in Mr. Pass's situation on Roman numeral 3 paragraph in the petition, it does state certain facts that I need to factually investigate. He tells me that he did the mental health evaluation. He tells me that he did pay more than, he hasn't paid all the restitution, but he's paid a good bit. And I think maybe a majority of it. And
$200 out of 5, right?
I'm sorry, a minority of 40%. So I'd like to factually investigate those 2 points and report back next week for the revocation hearing.
All right, we will reset that. Looking at my litigation manager.
Tuesday's the ninth.
Okay, that'll be May 9th, next Tuesday.
Very good. Thank you.
All right, I will reset those. Thank you.
Next, Your Honor, we have position 8 and 9, Mr. Upchurch, Marcus Upchurch.
That'll be mine, Your Honor.
Okay.
First point I would like to inquire about, it says he has several months left, but I think that the thing was on June, the sentencing was June 2nd. Was there a tolling order filed? Judge, you're on mute.
I understand. I was talking to my litigation manager.
Oh, I'm sorry. Okay.
I'm just teasing with you. I didn't want you to hear that, Mr. McLean. Hold on a second. We're looking on that tolling order.
That would make a big difference in what he's facing. So that's-
Okay.
You got no time, okay? Because we do have it, because I was doing. I'm sure. I don't know why they don't look at this shit before now.
Probation.
Yes, Your Honor.
Might need to mute.
I got something. You got one.
We're trying to check Mr. McLean. I don't know if we see one. We're digging a little bit.
If there's not a tolling order filed, I think the what he's facing is 30 days. I think that's correct.
Your Honor, a tolling order was issued for him with Judge Morrison back on December the 28th.
Okay.
Okay, so he's facing the 4.5 months.
All right. Probation, what's your recommendation?
We're asking to revoke the remaining balance since he has not reported to our office. He hasn't completed any drug screens. He hasn't started any of the anger management classes, and he had a revocation hearing with Judge Morrison on December the 28th, and he failed to appear before that hearing, and that's why a warrant was issued. He has 4 months and 17 days remaining.
All right, I will revoke him for those 4 months and 17 days.
We'd like to be heard.
Got to comply with the orders, Mr. Upchurch.
You're on.
Contact your attorney if you're having some issues and need resources so that your attorney can try to help you. Always tell defendants, call your attorneys when in doubt. But I'm going to have to revoke you today, okay? So you've got 4 months and 17 days?
Your Honor, we'd like to be heard on that.
Okay, go ahead.
Your Honor, he had major changes that happened. He lost his housing, he lost his job, and was unable to get things together. He was homeless on the street. This was very completely discombobulating. And so he does throw himself on the mercy of the court. I did check, and it was the case itself, was reduced to disorderly conduct and no further violent contact. He's a good father to his child. The child's mother was the victim in the case, and they get along great. She's in another state. He sends the money. But if your honor could minimize or cut down on the number of days he would have to spend on the revocation, that would be greatly appreciated, because that would get him back in instead with making those payments. He is apologetic. He is remorseful about having messed up his probation.
All right, probation.
Yes, Your Honor. Again, due to him not reporting to our office, keeping updated of his current situations, probation decision stands, we will request to revoke his probation.
And this is the DV case reduced to disorderly.
Yes, Your Honor.
Probation, do you have any history or pretrial?
I don't, Your Honor.
Okay, pretrial is there.
Yes, Your Honor, I'm here.
Give me some history, please.
Yes, ma'am. Let's see. Defendant has just one other cycle in Georgia, simple battery. The disposition is not listed. It just says forwarded for prosecution. Nothing else is listed on the GCIC. And the defendant also has a criminal history out of New Jersey, 3 arrest cycles. Let's see. Looks like 1 conviction for, let's see, possession of controlled substance. Let's see, disposition date on that is February 2015. Yep, that looks like that's the only conviction on there, Your Honor.
Was that a misdemeanor?
Okay.
He's indicating to me, Your Honor, that it may be a misdemeanor, which would mean to me it's probably marijuana.
That's correct, Judge, it is.
Okay.
So he does throw himself on the mercy of the court, and he knows he's facing some time here.
What, are there some resources in place to help him to not be back in this situation? I do hear that, but I just want to make sure that he has resources so that he can bring himself back into compliance.
Right, we do have this page, well, it's page and 2/3, nearly 2 pages, single spaced, of homeless assistance and shelters. And there's quite a few phone numbers. There's at least 3 dozen phone numbers on there that you can just start calling and get to work on that.
What's the arrest date?
I believe it would have been about 3 weeks ago, roughly. Yeah, I tell you, today's 20 days or 21 days, something like that. It's 20 days today. 20 days today.
All right, what I'll do is I'll revoke him for 30 days, credit for that time served of 20, so he has about 10 days left.
Very generous, Your Honor. Thank you.
All right, good luck to you.
Much appreciated. Thank you. All right, it's good to see you again and do it right this time.
All right, that's my ruling on that case, probation.
Yes, Your Honor.
Your Honor, we're gonna go back to the regular SAP calendar until we find to the other officer gets to the other probation. So I'm gonna go to position number 27, Mr. Kenneth Lewin.
And you're talking about Ms. Smith?
Yeah.
They've got a juvenile proceeding going on, and as soon as that juvenile thing is over with, you'll get with us from ACDC.
All right, is this an arraignment or a plea?
I believe it's an arraignment, Your Honor. It's not guilty. And he has a private lawyer that he's trying to get hold of. His family's trying to get hold of. So we'll just leave it at that. The not guilty, we would ask to waive the formal reading of the accusation and ask the court to simply tell him the maximum and watch your court dates.
All right. This is case number 17 CR 017258, Kenneth Lewin, or is it Lewin, I believe? Sorry if I mispronounced it. GUI, driving under the influence, less safe, failure to maintain lane and reckless driving. Offense date April the 1st, 2016. And Mr. Lewin, we're addressing your case today. And want to make sure that you first understand that you do have a right to remain silent. Anything that you state about the facts and occurrences of your case can and will be held against you. And I know that you are represented at this point by Mr. McLean, and we're going to formally arraign you today. He's waived the formal reading of the accusation. And again, I just read your charges. You've been formally accused by the Solicitor General's office of Fulton County, and these charges carry a maximum sentence of 1 year in jail or a maximum fine of $1,000 for each charge. Your case will be reset for a jury trial. The trial will be scheduled by the state court judge to whom this case is assigned as further notice for trial. Make sure that you keep your address updated with your attorney and with the clerk of court. And at the jury trial, you will have a right to an attorney. You do not have the burden to prove the charges against you at trial. The state, represented by the Solicitor General, will bear that burden and will have to convince the jury beyond a reasonable doubt in order to get a conviction in this case. If they do get a conviction, again, you could face a sentence of up to 1 year in prison or a fine of up to $1,000 for each charge that could run concurrently or consecutively. Based on the information, how do you plead to these 3 charges?
Not guilty, Your Honor.
All right, I will accept your plea of not guilty. This case will be reset for trial, for the notice for trial. You've been formally arraigned.
All right, I do feel compelled. This is complete hearsay, I must admit. When I interviewed Mr. Lewin, he told me that through the years, the lawyer that he's talking about was Rafe Banks, and Rafe Banks has got a lawyer in his office whose name starts with an S, he told me. And that's the guy that ran into him at the jail, and I believe it was Forsyth County, which is coming, and said, "What are you doing in here?" And he says, "It's that 2016 as a whole." And he says, "But we called on that, and we were told that that was not a viable case anymore." So this is, I've got to admit, Your Honor, it's pure hearsay that somebody called through the years and believed the case was dismissed. But it is a 7-year-old case. And if there's any consideration that he could have on bond, even without his private practice lawyer here, that would be greatly appreciated as well.
Is there bond already set?
I think it's a cash bond right now, Your Honor. I think that's, what was it, $2,500 cash bond?
Yes.
2,500 cash?
Right, if it were $2,500 good bond, he could probably make it. It is a 7-year-old case.
Pre-trial?
Yes, ma'am.
Do you have any history on this case?
Yes, Your Honor. Looks like defendant had a, let's see, possession marijuana less than an ounce. He received first offender treatment on that. Disposition date was June 2007. Case was sealed July 20.
2007?
Yep, case was actually sealed in 2017. So he successfully completed that one.
Do you have anything more recent in the last couple of years?
We have a felony conviction out of Forsyth County for possession of Schedule 1 or 2 controlled substance. Disposition date on that is October 2012. At least 3 violations of probation, I'm sorry. And let's see. and just the one FTA. Looks like nothing, no felony convictions within the last 10 years.
All right. Due to the history that I've heard, Mr. McLean, I will make that a surety bond for 2,500.
Very good. Thank you, Your Honor.
All right.
Next, we have position number 20, Kelvin Hunt. I believe he has private counsel.
Good morning, Judge. I'm in a brief conversation with the prosecutor. Could I stand down?
Yes. All right, we'll hold.
Next, we have position 34 and 35, Roman Hurtado.
We need to interview him.
You need to
Yeah,
interview
he
him.
was at CP House.
Okay, yeah, see if that's it. See somebody else. We're gonna hold on 34 and 35. We'll go to position 41, Mr. Deontay Thomas.
So he was
Okay.
staying with the house. CP House. Didn't know you had him in inside. Those are the only two like that. This.
We're gonna hold off on 41,
Okay.
and we're gonna go to position number 2, Mr. Corey Bass.
This is case number 23 CR 002435E. Corey Bass, you're charged of 1 count of loitering prowling. The offense date is April the 18th, 2023. This is going to be, this is the bond hearing.
That is my understanding, Your Honor.
Yes, Your Honor. Good morning, Mr. Walker. Yes, this will be a bond hearing and we'll waive arraignment and enter a plea of not guilty.
Okay. All right, state.
Yes, Your Honor. On April 18th of this year, law enforcement was dispatched to Kingsborough Luxury Apartments located at 3443 Kingsborough Road. Upon arriving at the location, they spoke with a resident who stated that she observed the defendant entering the building and pulling on 3 different doors to apartments. Thank God that each door was locked, but essentially he was trying to break into apartments at that location. Her being a resident, she reached out to 911. She gave a description to the officer. They canvassed the area and they were able to find the individual and take him into custody. Currently, he has a $1,500 surety bond. I don't think we've heard from pretrial, but I allow them to give any history to the court. We'll just ask that surety bond remain as said.
All right, pre-trial.
Yes, our defendant has 20 cycles beginning in 2009. Last arrest was in Clayton County, March 2023 for a probation violation. Looks like the underlying charges driving without license, theft by receiving stolen property. The defendant has a felony conviction out of Clayton County for theft by receiving stolen property, which received first offender treatment. Disposition date on that is October 2021. He has probation for 4 years on that one. He has another misdemeanor conviction for battery, December 2019. Out of Clayton County. At least 3 violations of probation, 2 FTAs, and 1, 2, 3. At least 4 of the misdemeanor convictions within the last 10 years.
All right, Mr. Walker.
I'm sorry, Your Honor.
Anything else you want to say? We've heard.
Oh,
the
no,
history.
just based on the history specifically, I feel as though a $1,500 surety is more than reasonable. We just ask that the court maintain the current bond.
All right. Mr. Dotis.
Thank you, Your Honor. Mr. Bass is 33 years old and he spent the last 14 days in custody at Fulton County on a $1,500 surety bond. He cannot afford any monetary bond, so we would request a signature bond. Mr. Bass is a lifelong resident of the state of Georgia and the Atlanta area. He's currently residentially challenged, but as I always do, I will provide him with a list of resources to help him get back on his feet. He's currently doing a work study to try to land back on his feet at the Interactive College of Technology in Chambly, where they're assisting him with getting certified to become a heating and air conditioning technician. And he plans on continuing that if given the opportunity. And to ensure that we're not setting Mr. Bass back and allowing him to be outside as a part of his defense and stay in contact with us, we would just request a signature bond.
And he's been in custody 9 days,
I have 14 days, Your Honor.
14.
Additionally, the offer was I believe a time served offer, so I don't believe he'd be a danger if released. I don't think the state feels that way either.
Say that again, Mr. Dotis.
The offer on the table would have been a time served, so he would have been released, but Mr. Bass maintains his innocence and wants to take this to trial. So I don't believe that the state feels that he's a danger to the community.
Well, Mr. Dotis, I don't know if he's a danger or not, so I'm not sure how you can state what I believe, but okay.
Fair enough, fair enough. I'm just going off what the offer said. Didn't mean to put words in your mouth. My apologies, Mr. Walker.
Does he have any family here?
No, sir. Mr. Bass is currently on his own. That's why I'm doing my best to ensure that he has all the resources he needs. And if necessary, we will have a social worker come out to see him. But again, I have provided him with resources, and I believe that he can stay in contact with us and let us know how we can help him.
Does have some history that I'm concerned about. I'm going to give him a $3,000 signature bond through pretrial so that he will need to report so we can keep up with him. So I will change it to a $3,000 signature bond through pretrial.
Thank you, Your Honor. All those conditions remain in place. Is there anything else I need to add?
Yes,
What level, Your Honor?
I'm sorry.
What level?
2.
Thank you.
Thank you, Your Honor. I'll have that paperwork sent out as soon as we get out of here.
Thank you.
Next is position 1 at Moore.
All right, position 1 is that Deshaun Atmore Mehta, 23 CR 002571C, charged with 1 count of theft by taking. Offense date October 30, 2021. Is this still going to be a plea?
Yes, I believe it's going to be non-negotiated with the issue of restitution. At the appropriate time, I believe the victim, India Ash, should be on the line, so I can let her confirm the amount that we're requesting. But
Okay.
go ahead and state what the state's recommendation is.
All right.
State is asking for 12 months to serve, 198 days, credit for time served, 99 days, balance probated, with no further contact with the victims, Miss India Ash and Mr. Clay West. A theft course, if I did not say that. And then we also are requesting restitution in the amount of $1,700 to Miss India Ash. $600 in cash was taken from her and an Apple MacBook. And that is what the restitution is for.
Okay, on the calendar, it's 3,500, so it's only
It's
1,700.
been, it's been modified to 17, Your Honor.
Okay. And nothing to Mr. West, all to India
Correct.
Ash.
Correct.
And then there's a stay away.
We did speak with the victim. She no longer resides at that location, so the stay away would not be needed.
Okay. All right. Is this your case, Mr. Dotis?
Yes, Your Honor, it is.
You've heard the state's offer.
Yes, Your Honor. We'd still dispute restitution. I will say, when I did speak with Mr. Atmore, the number I gave him was the $3,500. So now it's clear that it's actually $1,700. I understand the victim is here. Again, I don't have a legal basis or a value determination on the MacBook. I will note in the affidavit of arrest, it says that the property of India Ash with a value of $1,500 or less. The only thing issued in the warrant that says that they're accusing him of taking was the laptop. I don't see anything about any cash listed. So I would dispute restitution entirely, but I don't see, you know, any probable cause for restitution on money that was taken.
If it's not in the warrant, it's definitely in the report, but I can give the court a final answer. And if we could send, I see it, India Elan. I don't know if that's Miss Ash.
Right. Miss Ash, India Elan or India Ash, are you on the Zoom call? India,
Yes, I am.
all right. Do you wish to address the court?
I don't, but the cops, when we did
Hold
file
on
the
a
police
second,
report.
hold on a second, hold on a
Okay,
second.
sorry.
Cannot talk to you because I cannot see you.
Okay, hold on.
You don't have to turn on your camera before you can say anything,
Okay.
all right? And so if you wish to address the court, I will need to swear you in. So do you want to say anything or not?
Yes, I do.
All right, raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
Can you hear me?
Yes, I can.
Okay,
Yes, ma'am.
all right, put your hand down. What is it that you would like to tell me? There's a question here regarding restitution.
Well, for one, when we did file the police report, the cop, he actually told me that the only thing that could be accounted for was my laptop, but I forgot about the whole thing. I just received a phone call from you guys yesterday saying that court would be today. So, you know, I was at home when my items were stolen, but I was asleep. So, you know, he robbed the whole house pretty much and left.
Go ahead.
That's all I pretty much want to
So
Yeah.
is your MacBook in cash? And Mr. Walker is checking the police report.
This is my MacBook. What, ma'am?
It was a MacBook laptop?
Yeah, it was a MacBook Pro, and I had my rent money and cash in there. He was communicating with me through Instagram, trying to ransom to sell me my computer back. And I just told him no, that I'm not going to pay for something that's already mine, that I pay for out of pocket. So we cut off all communication, and I haven't heard or thought about this case because it was really scary. I did talk to a detective. Clay did as well. And then after that, I haven't heard anything about this case until yesterday.
Okay.
So I just totally moved on with my life and I forgot about it. I replaced my computer myself and let it go. So.
And that's approximately where the 1,700 is coming from for the MacBook?
Yes, that's I have replaced that. He did steal clothing items from Clay as well, but you know, I can just speak for myself. My MacBook was gone when we did because I was fearing for my life. So we did call the police the following day because the DMs were he kept sending me DMs in the middle of the night. So I'm a female, so I was just nervous.
I understand.
And that's when we called the police, and the police told us, he told me, I can't account for your cash, but I do know, you know, your laptop was missing. So I could, you know, file a police report about that. And I was like, okay, cool. And I just let it go after that.
Okay.
Because I didn't hear anything from it.
Okay, let me see what ASG Walker has discovered.
So I did check the report. The $600 was reported missing in the incident report to corroborate what Ms. Ash just stated. So it was a laptop taken along with $600 in cash. But I think the victim has made it clear of what was taken from her. between the laptop and I believe it was her rent money at the time,
It was my rent money.
which was
I
600.
just had started working, so it was my rent money in cash. I think the following week I had to pay rent and I had $0. So I had to start over. And I
So-
also was, fearful for just my surroundings because when I did speak to a detective, she was like, he is a dangerous man. And I could tell because it was a few incidents that did happen in the house. But, I didn't know him. I don't know him like that. I rent a room from Clay West. So, he is my landlord. So he was a guest of his and not mine.
And just to give the court some clarity, this case started out as a felony case. He actually was charged with felony terroristic threats based upon the threats that was communicated to Miss Ash. For whatever reason, the case was downgraded to our office and we kept the theft case. So nothing further at this time, but we are asking for that amount of restitution, Your Honor.
All right. I believe we were talking about the MacBook Pro, about 1,500 and then 600 in cash for the rent. So is that 2,100?
I think the MacBook was 1,700
Oh, 17, okay.
and then was 600 in cash.
So that's 2,300,
Correct.
okay.
And Your Honor, if I spoke with my client about the possibility of restitution remaining, but I think at this point we would request to withdraw our plea. If Mr. Atmore wants to.
All right, Mr. Atmore,
Mr. Atmore? So we understand now that with the offer that restitution is more than likely on the table, and so we discussed this. So I think we're going to withdraw our plea like we discussed, okay? Because this isn't what's holding it.
okay. So we're going to just, are you waiving arraignment or?
Yes, Your Honor, I'll waive arraignment and we'll plead not guilty to this case. I would ask Mr. Walker if you could please send me that incident report you had. My discovery was incomplete, so I want to make sure that we have that.
Okay, I can do that.
Thank you.
All right, we will further notice.
Thank you, Your Honor.
And Miss Elan, someone from the solicitor's office will be getting in touch with you.
Okay.
All right,
All right. Thank you.
thank you.
Mhm.
Thank you, Your Honor.
Position 14, 15, and 16. Mr. Grickley.
Yes, Your Honor, for positions 14 and 16, we will be waiving arraignment, and pleading not guilty. Position 15 is an FTA. We would request to have that set aside, but understand that might be sent back to the division judge.
All right, position 15, 23 FTA 000332, Rodney Grigley. And that offense date was March 22nd, 2023. State,
Yes, Your Honor. 1 second, because he has 3 cases. So 14 is going to be a not guilty.
and waive arraignment.
15 is also the not guilty, and the 16 is the FTA that they're asking to be heard on.
No, 15 is the FTA, 16 is waive arraignment.
Hold on 1 second.
Out of order.
So it's my understanding that I'm sorry. So 15 is the FTA connected to position 16. Got it. So in position 16, the defendant has FTA 3 times in front of Judge Dixon. Typically, it is the posture of the court to send back to the division judge who issued the bench warrant to make a final determination on bond. Again, I'm looking at Odyssey. It looks like he initially had a pretrial release bond on these charges. So it's the state's position, had the defendant been reporting to pretrial services once a month as required by pretrial services, he more than likely would not have FTA 3 different times. I'm showing FTA on the jury trial calendar 2/27/20, another FTA on 4/13/2021, and then a third FTA on March 22nd of this year, all in front of, the first two were in front of Judge Dixon. The third one, it was on an ORCA calendar. It's my understanding that there currently is a $3,000 surety bond on the FTA. So we would just ask that the court maintain that surety bond and send it back to Judge Dixon to make a final determination on the bond, since I believe she is the one who issued the initial warrant.
All right. Mr. Dotis, do you want to be heard any further?
I would just note, Your Honor, and I do understand that this is probably something that needs to go back to the division judge, but Mr. Grigley has been in custody in DeKalb County the past few years. I met with Mr. Grigley yesterday, and I reached out to an investigator. I wasn't able to get proof of incarceration in time for this hearing. This isn't the only thing holding Mr. Grigley, so I will let the division attorney assigned to him know that they need to get that proof of incarceration most likely, but I did want to bring that up and, address that in front of the court.
All right, well, I'm going to keep $3,000 surety bond and return it back to Judge Dixon. Yes, I guess if you do have that proof of incarceration for 2 years, that would be something that Judge Dixon could take up.
Correct, Your Honor. I understand. Thank you.
All right, thank you.
Position 4, Brown.
Is this going to be a plea?
My apologies, Your Honor. I was speaking with a client. What position?
4, Ronnie Brown.
Yes, Your Honor. My understanding is this would be a negotiated plea.
All right, this is 23 CR 0025553E. Mr. Ronnie Brown, you're charged with 1 count of battery. The offense date is 8/24/2022. State?
Yes, Your Honor. The state's recommendation is going to be 12 months to serve 10 days, credit for time served of 5 days. Balance probated with no further contact with the victim, whose name is Lawrence Murphy. An alcohol drug evaluation with any necessary treatment and 4 weeks of anger management.
All right. Is that your understanding, Mr. Dotis, of the offer?
That is my understanding, Your Honor. We would request Mr. Brown to switch over to non-reporting status upon completion of all conditions. And if Your Honor would give Mr. Brown a break on probation fees to help him get back on his feet when he's released.
State have any objection to him going non-reporting once he's completed all the conditions?
No objection, Your Honor.
I'm not going to waive any fees at this time.
Understood, Your Honor.
All right. Mr. Brown, are you ready to plead guilty here so I can take your plea?
Yes, ma'am.
All right. I need to place you under oath. Can you raise your right hand for me? Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, you can put your hand down. Mr. Dotis, do you stipulate to venue, identity, and factual basis?
Yes, Your Honor. I do stipulate to the 3 elements for the purpose of this plea.
All right, Mr. Brown, it's my understanding that you wish to plead guilty to 1 count of batteries. Is that correct?
Yes, ma'am.
All right, I need to ask you a series of questions in order to accept your guilty plea. The first one being, are you presently under the influence of any medication, drugs, or alcohol?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
I couldn't hear you.
Yeah, are you satisfied with the services and representation of your attorney?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up or waiving your right to the presumption of innocence?
Yes, ma'am.
That you're giving up and waiving your right to remain silent and not testify against yourself?
Yes, ma'am.
That you're giving up and waiving your right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And are you prepared to agree to waive these rights today?
Yes, ma'am.
Has anyone told you that you'll receive a lesser sentence for pleading guilty?
No, ma'am, only what, you already mentioned.
Okay. Has anyone promised you anything to plead guilty?
No, ma'am.
And do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea here today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, ma'am.
And as to the charge of battery, how do you plead?
Guilty.
All right, and you've heard the conditions. Again, you have to have no further contact with Lawrence Murphy, and you're to do an ADET, which is alcohol and drug evaluation, and a 4-week anger management course. After you complete all of those, then you can go non-reporting to probation. All right?
Yes, ma'am.
All right, that will conclude the plea. I will accept your plea. All right, good luck to you, Mr. Brown.
Next is positions 24 through 26, Latham.
Your Honor, I saw him in the jail yesterday, and he tells me that there is a lawyer who's getting together his cases in Superior Court, and he believes he will also have him do these cases. Your Honor, these cases are not, he wishes to plead not guilty in all three.
All right, do you waive the formal reading of the accusation if we're going to do arraignments?
We do.
All right, Mr. Latham.
Yes, ma'am.
All right, I'm going to arraign you on all three cases, positions 24, 25, and 26. Your attorney has waived the formal reading of the accusation, but on position 24, 19 CR 003159F, you're charged with 1 count of battery and a 2nd count of simple battery. The offense date is February 16, 2019. And I understand that you wish to plead not guilty. Is that correct?
Yes, ma'am.
All right. And so you realize that these cases have already been accused by the Solicitor General's office here in Fulton County, and that each of these charges carries a maximum sentence of up to 1 year in jail, as well as a $1,000 fine. It could run concurrent or consecutive. Okay.
Yes, ma'am.
All right, so you've been arraigned on the first position 24, and that case will be further noticed for trial with the division judge. And position 25, 20 CR 006119F, you're charged with 7 charges: hunting without permission, criminal trespass 2 counts, hunting without a license, expired or no license plate on your decal, criminal trespass, and fishing or hunting, again, without a license, all with the offense date of, looks like October 23rd, 25th, and 30th of 2020. And again, how do you plead to those charges?
Not guilty.
Okay, and your attorney has waived the formal reading, and you're going to be arraigned on this case. Again, each of those charges carries a maximum sentence of up to 1 year in jail, as well as a $1,000 fine. They can run concurrent or consecutive. Your case will be further noticed for trial and sent back to the division judge for scheduling. All right.
Thank you, ma'am.
And then the last one is 20 CR 006121F. You're charged with 1 count of theft by taking. Excuse me, and that offense date is March the 1st, 2020. Again, your attorney has waived a formal reading. And how do you plead to the charge of theft by taking?
Not guilty.
All right, and again, this case will be sent back to the division judge for scheduling for trial, further notice for trial. And again, this charge carries a maximum sentence of 1 year in jail, as well as a maximum fine of $2,000. All right, you're being formally arraigned on these 3 cases, all right?
Thank you, ma'am.
All right, thank you.
Position 11, Mr. Fernandez.
Okay.
And Your Honor, this is a private attorney, Mr. Robert Booker. I will note that this position has been reset like every week for a couple of weeks, so I would check to see if we've been in contact with Mr. Booker.
That's correct.
Was that Mr. Dotis talking? Can you repeat that again?
My apologies, Your Honor. I was just saying that this is a private attorney, Mr. Robert Booker. This position appears on this calendar every week since the beginning of April, and Mr. Booker has not appeared. I don't know if Mr. Walker knows anything, but
I have not heard from his attorney, but it has been reset multiple times. I'm not sure if the clerk's office has been able to be in touch or send Attorney Booker any notices. Not that it makes a difference, but I will know that the defendant is being held on no bond and close to $100,000 bond on more serious felony charges. But I have not had any contact with Mr. Booker as far as I can recall.
Judge, this is Ms. Lewis. I have been in touch with Mr. Booker's office. Mr. Booker, office is aware of this court date. They selected this court date. I gave them a choice of last week from Tuesday or Thursday. I do not know why they're not on the line at this time. I will try to contact them again. But he was not certain why the case keeps being on the calendar because he did ask for a jury trial in this case. And I think it's because of the case manager put it on the counter. So I will reach out to him and see what he said. If he wants to waive his arraignment, whatever, and make that note now, announcement, whatever he chose to do, then I'll come back on the line and let y'all know and from that point.
Okay.
I'll try to reach out to him.
Thank you. We'll hold for your announcement. And this is Mr. Nicholas Fernandez, correct?
Correct, Your Honor.
Okay. We'll hold for a second. Let's see if we can get in touch with the attorney, Ms. Fernandez.
And then at the appropriate time, I do have an announcement on position 20, Your Honor.
Okay. What's your announcement?
I did talk to Attorney Rockwell. Her defendant, or her client rather, is being held on felony charges. She has a hearing right now, so we're just going to ask that this is reset to next Tuesday's SAP calendar, since he's being held on other serious charges with no bond.
All right. Position 20 is reset to, is that February 9th? Wow, I went way back to February. Don't want to do that. I'm sorry, May 9th. I'm sorry.
Next is positions 42 and 43, Willis.
Hold on one second. We have Attorney Booker. We're going back.
Morning, Judge.
Good morning. How are you?
Hey, not too bad. Still here in Gwinnett.
All right. Do you have position? Mr. Hernandez, there he is. This is 20 CR 0017778Y. What is your announcement, Mr. Booker, on this case?
Judge, we're still announcement ready. My client's in custody not for this case, but for a felony case that looks like it may be headed to mental health accountability court. But we're still announcement ready on this case.
All right. And so, has he been arraigned or not?
I believe we previously waived arraignment.
Waived arraignment. Okay. All right. This case will be reset for the notice for trial with the division judge. Is there anything else you need to take up?
Not on my behalf, Your Honor.
Okay. All right. Thank you.
Thanks for holding for me. May I be excused?
Yes, you may. Thank you. All right, I'm sorry, deputies. Who do we have next?
This is, I'm sorry, that's full enough, right? This is Mr. Willis, who's number 4243. It's a negotiated plea, Your Honor.
You're my attorney.
42 and 43 is ready.
Thank you. This is 22 CR 0076928, James Wesley Willis. Charged with 1 count of theft by shoplifting, fixed date 11/7/2022, and 43, 23 FTA 000337. It's an FTA from February the 14th of 23. Stay.
Yes, Your Honor. So the state's recommendation on position 42 is 12 months to serve 42 days, credit for time served 21 days, balance probated with a theft course, and to stay away from the incident location, which is 3332 Colville Avenue. That's COLVILLE Avenue is the corner market. And then for position 43, the state's gonna no process.
All right. And what type of market did you say that was on Colville Avenue?
It's a corner market.
Corner market, okay.
Mhm.
All right, is that your understanding, Mr. McLean?
Yes, it is, Your Honor. He asked the court to accept his negotiated plea of guilty, and he stipulates to video identification and factual basis. Your Honor, I would ask the court also, in addition to the negotiated plea, what we oftentimes ask for outside of that is the court give him a financial break on the probation fee, because he works part-time at a charity and doesn't have much money. He lives 3 blocks from the place, and he understands he will not go back there again. And he stole a sandwich.
All right, I'll give him a 6-month waiver of fees. All right, Mr. Willis, we're getting ready to take your plea. Can you raise your right hand for me?
Yes, ma'am.
You swear that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Oh, yes, ma'am.
Okay, put your hand down for me. I'm gonna ask you a series of questions in order to accept your plea. Again, you wish to plead guilty to 1 count of theft by shoplifting, is that correct?
Yes, ma'am.
All right, are you presently under the influence of any medication, drugs, or alcohol?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Can I ask you something?
Depends.
Go ahead. It's a small case. I don't think there'll be the arm.
What's your question?
You said I had to take a test about shoplifting, $200. I don't have it because I work this part-time.
I was telling him, Your Honor, that it may be, I'm not sure what the charge is for a shoplifting class, but it could run up to $200 for a typical shoplifting or theft class. And because of that, and because he works part-time, I told him I would ask the court to waive some of the $49 a month fee. And Your Honor is indicating that it can waive 6 times 50 is, I mean, that's $300 worth of fees that Your Honor is willing to waive for him. So if he's got his math correct in his head, Your Honor has basically done what he's asking.
Correct, and then you'll be able to pay for the class. Okay?
How much is the class gonna be?
Class, you have to find the class there. If you can find a free one, that'd be great, but I don't know that you can. I know that Operation 21 is available on the internet, but I don't know that you do internet. So
I don't know how to do internet.
I imagine not. So, sir, find a place that gives a theft class, seek some guidance from the probation officers, find a place that gives the theft class, shop around, get the cheapest one you can get. They're all pretty much the same.
And you may have to go to the library or something like that to get on the internet to be able to take a class if you're able to do that. But that's why I agreed to waive 6 months of the probation fees to help you out.
So I just go 6 months instead of a year?
I'm sorry?
I just have to go 6 months instead of a year.
No, it's a year, it's 12 months probation, but I have waived 6 months of the fees to help you so that you can find a course to take. And you have to do it in those first 6 months. Because after that, you may have to pay the other 6 months of fees if you have not completed all of the requirements, which is basically the theft class. So as soon as you get out, you need to complete that as quickly as you can.
And do I go to my probation for that?
Yes, they will help you to find a class.
Okay, thank you.
Okay, so let's finish with your plea. Are you satisfied with the services and representation of your attorney?
Oh, yes.
All right, do you understand that by pleading guilty, you're giving up or waiving your right to the presumption of innocence?
Yes.
And that you're giving up or waiving the right to remain silent and not testify against yourself?
Yes.
And that you are giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And you are prepared and agree to waive these rights today, is that correct?
Yes.
Has anyone told you that you'll receive a lesser sentence for pleading guilty?
No one told me.
Has anyone promised you anything to plead guilty?
No.
And do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea here today?
Say that again, I didn't hear you.
If you're currently on probation, your probation may be revoked because of your guilty plea today.
Oh, no.
Okay, and do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, ma'am.
And as to the charge of theft by shoplifting, how do you plead?
Guilty.
All right, so I will accept your guilty plea, and once you get out, you'll report to probation and they'll help you with the class, okay?
Yes, ma'am.
All right, good luck to you.
Thank you.
Huh?
Your Honor,
Yes.
and we told position 20, he didn't hear why he was reset, Mr. Kelvin Hunt.
Let's see. He's reset to May the 9th. And what was your question?
Yeah.
Oh, why was I reset?
Your attorney asked for it to be reset. She's in another courtroom. Attorney Renee Wackrill is your attorney, correct?
Yes.
Correct?
Yes, ma'am.
Okay, so she asked that it be reset to next week. I think she's still talking to the state and she will get back to you to let you know, if there was anything that could be worked out.
Yes,
So
ma'am.
that's why it's reset to next week,
Yes, ma'am. Yeah.
okay?
And next we have position 12 and position 13, Mr. Ashton Green, 12 and 13.
Huh?
Good morning, how y'all doing?
Let's see, what are we doing? 12 and 13. This is a negotiated plea and a no pros.
Yes, Your Honor.
We would request, Mr. Green, would like to use an interim plea of NOLO on position 12.
The years no longer than last 5 years.
My understanding is he has not. I didn't see anything and he tells me he does not believe he has.
There's no objection from the state, Your Honor.
Okay, all right, I will accept a NOLO plea on position 12. This is 20 CR 003857E. Ashton Green, you're charged with 1 count of simple assault, family violence. The offense date is October the 21st, 2018. State.
Yes, Your Honor. The state's recommendation is going to be 12 months probation with the condition of FFIP with no further contact with the victim. If you give me 1 second, or we can come back to it, I can give you the victim's name.
Okay.
I believe it's Michael Patton, but I'll let Mr. Walker confirm that.
Actually, that's correct. It's right here in front of me. It's Michael Patton.
Okay.
Okay, I just want to make sure we're on the same page.
Okay, thank you.
Yes, Your Honor, that's our understanding of the offer. I would note that Mr. Green should have 29 days of credit between the FTA and the underlying charge. So we would ask that be reflected in the plea paperwork. Other than that, we do stipulate to the factual basis, venue, and ID for the purpose of this plea. Additionally, we would request Mr. Green to switch to non-reporting status upon completion of the FVIP program.
Okay. You can go non-reporting upon completion of the FVIP course. And then we'll add 29 days credit. And that would be credit for time served, correct, Mr. Walker?
Yeah, balance probated with the
Balance
active
probated.
course.
Okay. All right, Mr. Green, are you ready to take your plea?
Yes, ma'am.
Raise your right hand for me. Do you affirm that the testimony that you're about to receive is the truth and I've got to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, put your hand down for me. I'm going to ask you a series of questions. State, you stipulate the venue, identity, and factual basis.
Well, defense does, Your Honor.
Okay, all right. Mr. Green, are you presently under the influence of any medication, drugs, or alcohol?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Ma'am.
Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Do you know though?
I'm sorry, by pleading nolo, that you're giving up and waiving the right to the presumption of innocence?
No.
And that you're giving up and waiving the right to not testify against yourself?
No.
That you're giving up the right to trial by judge or jury, whichever you prefer?
No.
And that you're prepared and agree to waive these rights today, is that correct?
No.
Has anyone told you to receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
And do you understand that if you're currently on probation, your probation may be revoked because of your no-low plea today?
Yes, ma'am.
And do you offer this no-low plea freely and voluntarily with the full understanding of the charge against you?
Yes, ma'am.
All right, so as to the charge of simple assault, family violence, how do you plead?
No, though.
Okay, all right, I will accept your no-low plea. And you understand your conditions with the FVIP course. And after that, you can go non-reporting. You complete it pretty quickly in your probation. Otherwise, you will be on probation until you complete that, okay?
Okay.
And you'd have no further contact with Michael Patton.
Okay.
All right, I will accept your plea. And that will conclude this case. Good luck to you.
Great. And Your Honor.
There was no stay away, is that correct, Mr. Walker?
There is no stay away.
Okay, thank you.
Thank you. Thank you. Your Honor.
Position 28, Mr. Mays.
Okay.
My apologies. What position, Your Honor?
28, Mr. Mays.
That's McLean's client. He says he's going to be on the phone for a second dealing with another client. If we could come back.
Okay.
Mr. Dotis, did you want to talk to Mr. Miller, probation?
If you have Mr. Miller, then I'm happy to.
The 22391. Nothing.
All right.
All right, thank you.
I'm talking about
We got position 6, Ellis.
All right, this is Telly
Miller.
Ellis.
He's, Mr. Dotis is on the phone.
Oh,
I need to fix it.
All right, who do we have again, Deputy?
You give a trial rights.
Your Honor, both attorneys are tied up with clients on the phone right
You
now.
give seven trial rights such as cross-examination, standard proof, right to remain
Let's
silent.
see Ms. McLeod on. Does she have a case?
And I believe Cloud's case is Pinckney, and I believe he's on the 4th floor. Duffy, you have Pinckney with you?
Do I have what?
Pinckney?
Okay.
No.
Now, I'll sign in now. You'll see the judge in a minute. Thank you.
This is Mr. Ellis.
All right, his attorney is on the phone.
Yes.
Your Honor, Mr. McLean is back.
I'm available, Your Honor, for Mr. Hayes, and I would like to make a new announcement. We had to be announced on Simpson, and he is now a negotiated plea.
And you said this is Mr. Simpson?
No, Your Honor, I was saying that I just got off the phone with Mr. Simpson, and he's a negotiated plea now because he was to be announced because he was at ACDC. But
Okay.
Mr. Mays was waiting on me, and he is a negotiated plea as well.
Okay. All right, this is Mr. Hayes in front of us, correct?
Mays with an M.
I'm sorry, Mays. I keep saying Hayes, Mays, M.
Your Honor, this is going to be a fairly simple one. He's only being asked on probation to do two hours of anger management. So he's very enthusiastic about that.
All right. This is 22 CR 00758J. Is it Quadarius Mays?
Yes.
In charge of 1 count of battery. Defense date is August the 12th, 2020. All right, ASG Bickerstaff.
Yes, Your Honor. So the state's offer is 12 months to serve 18 days, credit for time served 9 days, balance probated to a 2-week anger management course, no further contact with Miss Sheila Manis, that her last name is spelled Mannis, and also a stay away at the incident location, which is 503 Camelot Drive.
All right.
On 4 North on the Zoom, is that the camera showing 4 North?
I'm sorry.
Do we have Mr. Mays on 4 North? Because it doesn't indicate name, it just shows location.
Yes, 4 North, Mr. Mays.
Just want to
Mays?
make sure he was.
Okay. And so, Mr. Mays, you heard the state's offer. Is that your understanding?
I didn't hear it, Your Honor. My apologies.
All right, could you state that again?
Yes, so the state's offers 12 months to serve 18 days, credit for time served 9 days. The balance is probated to a 2-week anger management course, no further contact with the victim, in this case, Ms. Sheila Manis, and a stay away from 503 Camelot Drive.
All right.
Okay. And I'm going to take your plea. I need to swear you in first, Mr. Mays. Raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
Okay. All right. You can put your hand down. I'm going to ask you a few questions in order to accept your plea. State, do you stipulate? I'm sorry, not state. Mr. McLean.
Oh, yes, we do stipulate to bank basis genuine ID, Your Honor. Yes.
All right, Mr. Mays, are you currently under the influence of any medication, drugs, or alcohol?
No, Your Honor.
Are you satisfied with the services and representation of your attorney?
Yes, Your Honor.
Do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes, Your Honor.
You understand that you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, Your Honor.
We understand that you're giving up and waiving the right to trial by judge or jury, whichever you prefer.
Yes, Your Honor.
And you prepared and agree to waive these rights today? Has anyone told you that you will receive a lesser sentence for pleading guilty?
No, Your Honor.
And has anyone promised anything to plead guilty?
No, Your Honor.
You understand that if you're currently on probation, your probation may be revoked because of your guilty plea here today?
Yes, Your Honor.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, Your Honor.
All right, so remember, you'll be on probation. And that balance will be probated until you complete that 2-week anger management course. We have no further contact with Sheila Manis, and you're to stay away from 503 Camelot Drive, understood?
Yes, Your Honor. Understood.
Hopefully, maybe that could go to non-reporting once he completes his class.
After you complete the class, I'll let you go to non-reporting. All right?
The class is 2 weeks, you said?
Yes, 2 weeks anger management, correct.
Okay, I understand, Your Honor.
All
Thank
right,
you.
so the quicker you do that, the better it'll be, okay?
Yes, Your Honor. Thank you.
All right, good luck to you.
You too. Enjoy the rest of your evening.
Position 37 and 38, ACDC.
38. That's Rayfield Simpson, number 38.
Okay. He's 37 and 38.
37 and 38, yes, Your Honor.
All right, 23 CR 000018J, Rayfield Simpson, charged with 1 count of criminal trespass and possession and use of drug-related objects. Offense date December 30th, 2022. State.
Yes, Your Honor. So for position 37, the state's offer is 12 months to serve, 144 days, credit for time served 72 days, balance suspended. We're just asking for a stay away at the incident location, which is the Catalyst Apartments at 1011 Northside Drive, Northwest. And then for position 38, we're going to no pros.
Okay. All right, set your understanding, Mr. McLean.
That is our understanding of the terms. He does ask the court to accept his negotiated plea while he stipulates to factual basis, venue, and ID.
All right. All right, Mr. Simpson, I'm going to take your plea at this time. Are you ready? Raise your right hand. All right, do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yeah.
Okay, all right. I'm gonna ask you a series of questions in order to accept your plea to these 2 charges. And the first question being, are you presently under the influence of any drugs, medication, or alcohol?
No.
Are you satisfied with the services and representation of your attorney?
Yes.
Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes.
Do you understand that you're giving up and waiving the right to remain silent and not testify against yourself?
Yes.
And that you're giving up and waiving the right to remain silent? I'm sorry, giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes.
And are you prepared and agree to waive these rights today?
Yes.
Has anyone told you that you'll receive a lesser sentence for pleading guilty?
No.
Has anyone promised you anything to plead guilty?
No.
Do you understand that if you're currently on probation, your probation may be revoked because of this guilty plea today?
Yes.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes.
All right, so as to the charge of criminal trespass and possession and use of drug-related objects, how do you plead?
Guilty.
All right, I will accept your guilty plea. You understand your conditions? And is there anything else, counsel?
Nothing else, Your Honor.
All right, good luck to you, Mr. Simpson.
Position number 41, Mr. Deontay Thomas, position 41.
Your Honor, we're going to waive arraignment on that. Mr. Dotis will file for us, and we're just gonna waive that. That's not guilty, and bond is moved because he's already made his bond. This is not.
Okay, all right.
Thank you. Then I get to the guy with second position.
And were we able to get a Spanish interpreter for positions 34 and 35?
I don't know.
That's the clarification. I had sent a thing to Mr. Dozy to find out what he was talking about, because he said position 41. So what positions are you requesting Spanish interpreters for?
That's my apologies. I think I accidentally responded to Mr. Jordan with that. Yeah, I got the position wrong. It's position 34 and 35. My apologies.
I will try.
Adrian.
Yeah.
All right, who do we have next? While we're waiting on an interpreter.
Position 6, Mr.
Okay.
Ellis.
All right, this is not guilty, addressing bond.
Yes, Your Honor, and I will submit a waiver of arraignment.
Okay. All right, this is position 6, 23 CR 002501J, Telly Ellis, charged with 1 count of battery, I'm sorry, 2 counts of battery and 1 count of simple assault. Offense date is July the 11th, 2022. State?
Yes, Your Honor, since it's a bond hearing, can we have pretrial state the history, please?
Oh, I'm sorry, yes, pretrial.
Your Honor, I stepped away for just a second. Which one are we on?
Position 6, Telly Ellis.
Okay. Hold 1 second.
Mhm.
Give me 1 second. I'm almost done looking through it. Give me 1 second. You can come back to me in 1 minute.
I can give the factual basis, Your Honor.
Okay.
On the incident day, police responded to 532 Cleveland Avenue in regards to a fight with a weapon call. Upon arriving at the incident location, they spoke with the victim, Mr. Floyd Cloud, along with the independent witness, Latanya Miles. Mr. Cloud reported to police that the defendant did try to enter into the apartment that him and Ms. Miles stay at. When he advised to the defendant he was not welcome into the home, the defendant became irate and he pulled out a firearm. At that time, the defendant and Mr. Cloud began to struggle and fight over the firearm. The defendant did bite the victim in both of his shoulders. At that time, Mr. Cloud essentially was unable to hold the defendant off. At the time, the defendant did take the firearm and strike Mr. Cloud in the head. He did leave the scene. Police did observe the gash from being pistol whipped by the defendant. They also spoke with the witness, Latanya Miles, I believe it was her apartment, who stated that the defendant at that time began to text her and saying that he was going to hold her responsible. She responded and asked him if she was being threatened, and he said it was not a threat, it was a promise. At this time, he currently is being held on a $15,000 surety bond. I believe this case started out as a felony. It has been sent to our office. And that $15,000 surety bond still is intact. I would ask that the court maintain it. And if pretrial is ready, I would ask for her to read the history.
Okay. Holding for you, pretrial.
All right, yes, Your Honor. Looks like the defendant is a multi-state offender. He has 5 arrest cycles out of Georgia, 1 out of Alaska, and 8 out of North Carolina. The defendant is a convicted felon. He doesn't have any convictions out of Georgia in the last 10 years. Let's see. The 1 arrest out of Alaska looks like it did not. Making sure that one did not result. Yeah, that one did not result in a, let's see. Well, that conviction is outside of the 10-year period. Last arrest in Georgia was April 20th, 2023, possession, use of drug-related objects. No disposition is listed for that as of yet. It looks like all of the history it's substantially older than 10 years. So it looks like nothing, it's like 2005 or let's say 5, North Carolina. Yep, so nothing within like the last 10 years.
All right. All right. All right, Mr. Dotis.
Yes, Your Honor. Thank you. Mr. Ellis is 48 years old. He spent the last 13 days in custody on a $15,000 surety bond that he cannot afford. And as we heard, there's no convictions in the past 10 years. I didn't hear any FTAs or VOPs. Mr. Ellis has spent the last 3 years in Georgia. I don't believe he's a flight risk. He has requested assistance with housing, which I am going to provide. And I also have a sister's number who I left a message with, and we'll continue talking with her. But with how short we have to interview, I was able to leave a message, and we do plan on having contact with any family in the area. Mr. Ellis has a job with landscaping at Love's Lawn Services that he believes he can return to, but he is in danger of losing that job given his time in custody. He's also trying to supplement his income with any available restaurant positions, as he has history with that. We are requesting a $5,000 surety bond in total to ensure that we can assist Mr. Ellis with any available resources to help him pay with bond, as he told us that he cannot afford any monetary bond. Additionally, I will note that the current bond, the $15,000 surety bond, is still under the felony case number. I don't know if we need to set either, even if, no matter what we do, if we need to set new bonds on the misdemeanors, and I'm not sure if there's paperwork we need to file for the felony hold to make sure that that's disposed of, so that doesn't keep holding him. But anything we can do, we will do. But Mr. Ellis does maintain his innocence and wants to be a part of his defense from the outside. So we would ask for that $5,000 surety bond.
All right, I will reduce it to a $11,000 surety bond, $4,000 each on the battery charges and $3,000 on the simple assault. So that's $11,000 surety bond. And then I guess the same conditions from before.
Yes, the state will be asking for a stay away from 532 Cleveland Avenue. No contact with the victims, Floyd Cloud and Latanya Miles.
All right. No drugs, alcohol, or weapons while on bond. All right, that should conclude this matter.
Understood, Your Honor. And just to confirm, is there any paperwork I need to file to have the felony charge removed? I don't want to add an $11,000 bond and then not have this $15,000 one keep showing up. I just want to confirm.
What's that, Mr. Jordan? Does he just do the bond modification order? He was making sure the felony wouldn't show or give him a bond on the felony of the 11. I'm reducing the 15 to 11 on the misdemeanor charges.
Oh, that's fine. Once we send it to the jail, they'll update the jail.
Right. Once we send it to the jail, they will update the jail screen.
Thank you, Your Honor. Thank you, Mr. Jordan.
All right.
Position 30,
This is 23 CR 002077J. Zachary, is it Arata?
Yes, Your Honor. That's going to be a not guilty. I talked to his grandfather on the phone, who gave me the phone numbers of a couple of people who are going to be setting up some rehab situations. But for now, Your Honor, the best thing to do is simply plead not guilty and work on those avenues. The family will continue to discuss the bond situation, and we could actually waive this matter as a not guilty, waive the arraignment.
Okay.
We'll talk with you further, Mr. Arata.
Sorry?
I was trying to
This will
get
be
hold
further.
I'm
Go
sorry.
ahead.
Oh, Mr. Arata was trying to get hold of a Mr. Jason Price, and I think it's, where'd it go?
position 36 is next.
That's okay. I'll tell him who I was trying to get hold of later. But we'll just waive that, Your Honor. It's not guilty.
Okay.
Waive arraignment. Thank you.
Thank you. This is position 36, 23 CR 002570Y. Mr. Is it Ambrose Serginio? I'm sorry if I'm mispronouncing the last name. Charge of 1 count of theft by shoplifting, Penn State 5/4/2020. Is this a plea?
It is a negotiated plea, Your Honor. 3 years ago this week, Walmart, and we would ask to stipulate the venue, factual basis, identification, and ask the court to accept the negotiated plea.
All right, state.
Yes, the state's offer is 12 months to serve 14 days. Credit for time served 7 days. Balance probated to a anti-theft course and to stay away from the Walmart at 844 Cleveland Avenue.
That was Wynn Avenue?
844 Cleveland.
Oh, Cleveland.
Mhm.
All right.
And I'm reminding Mr. Sergenio, remember, Mr. Sergenio, it's going to be your responsibility to find that theft class. You can ask for help from the probation department, but the probation department doesn't really give the class. You must find the class, pay for it, take it, and prove it. 4 things. Find it, pay for it, take it, prove it. Do those 4 things and you'll be fine.
Okay.
All right.
All right. Mr. Is it Serginio?
Yes, ma'am.
Okay, and you wish to plead guilty to this one count of theft by shoplifting?
Yes, ma'am.
All right, I'm gonna ask you a series of questions in order to accept your guilty plea. Can you raise your right hand for me? Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, put your hand down. It's my understanding that you wish to plead guilty. Are you presently under the influence of any medication, drugs, or alcohol at this time?
No, I'm not. No, I'm not. No, I'm not.
All right, are you satisfied with the services and representation of your attorney?
Yes, ma'am.
And do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes, ma'am.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
And that you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
Are you prepared and agree to waive these rights today?
Yes, ma'am.
Has anyone told you you receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
Do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea here today? And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, ma'am.
All right. I will accept your guilty plea as to the charge of theft by shoplifting. And you understand what the conditions are. You can take that anti-theft class and to stay away from 844 Cleveland Avenue. You understand that?
Yes, ma'am.
All right. I will accept your guilty plea.
Your Honor, may I comment that I looked at the list of items taken, and they were personal use type items. He was not any kind of person professionally boosting events on the street. This was a mistake on his part, and we would ask the court to stop the probation, to make it non-reporting or something like that once he finishes that course.
Okay, once he finishes the course, he can go to non-reporting.
Position 3 and 4 on the probation calendar. Mr. Miller, Keith Miller.
Okay.
And Your Honor, we do have the Spanish interpreter on the line for position 34. If she could call courtroom 2 at 293, what is it?
It's 404-612-2392.
All right, I think she's doing that now.
Thank you.
So we're back to probation back on with us. Probation.
I think that's Harris's name.
Okay, there you go. All right, this is position number 3 and 4, 20 CR 004209E. One count of simple battery, offense date 7/16/2020, and then 23 PV 000321. Probation violation from December 28, 2022. Right? Probation?
Yes, Your Honor. You ready, Your Honor?
Yes.
Okay. Mr. Miller was sentenced on August 11, 2022 to 12 months to complete the domestic violence classes. As of today, he has not reported to our office. He had a prior hearing on December the 28th with Judge Morrison, and he also failed to appear for that hearing with her. As of today, Mr. Miller's case has 6 months, 21 days remaining probation. Recommendation is to revoke his probation.
All right. Mr. Dotis?
Thank you, Your Honor. I spoke with Mr. Miller, and I also spoke with Mr. Miller's brother, Fareed Miller, who I believe was on the Zoom a few weeks ago when we tried to address this. But I spoke with him again yesterday. He couldn't be on the Zoom, but I do have information on that. Last fall, shortly after pleading guilty, Mr. Miller's mother passed away after a battle with cancer. Mr. Miller is currently receiving disability, and his mother was really the rock that, you know, helped him keep it all together, and his world just collapsed with the death of his mother. His brother and father live in North Carolina, but Mr. Miller was really on his own, and he really struggled in trying to get everything together, and the death of his mother just cast a huge shadow over his life. He also was unclear on what exactly was what probation entailed, and he mentioned to his brother that, you know, he had court appearances, and he thought that he was, and his brother thought that they were doing the right thing by speaking with the Fulton County Sheriff, but they didn't realize he was on probation about the situation and didn't speak with the probation officer about making sure that he was helping him do what he needs to do. Moving forward, he will have that support. But after speaking with Mr. Miller and his family, we've all come to the decision that Mr. Miller is not a good candidate for probation, and he understands that. I understand that probation is recommending him to serve to revoke and serve the 6 months and 21 days, but we would just ask the court to revoke Mr. Miller's probation and give him, he served 13 days originally for the charge before pleading guilty, and he served 40 days on the VOP waiting for his hearing. So we would just be at the mercy of the court to request that Mr. Miller be given credit for the 53 days.
Unknown caller.
I believe the interpreter is not on mute. Okay. Additionally, I spoke with his brother who lives in North Carolina doing owning a dock building company on a lake, and they indicated that as soon as Mr. Miller is released, they're going to come down and get him and bring him up to North Carolina and ensure that he's properly taken care of, and, you know, ensure that he has a solid family support to help him get back on his feet, as well as offering him a job with the dock building service. So as soon as given the opportunity, Mr. Miller is going to return to his family in North Carolina, and he understands, you know, that he will be given a second chance, that he needs to do right and stay out of trouble. So we would just ask to go forward with no further probation and just give him time served.
Okay.
Sure.
And what did you tell me about his work and family history?
Yes, Your Honor. So Mr. Miller's only family in the Atlanta area was his mother, who he was living with. After his mother passed away, he had no one. He has a father in North Carolina and a brother, both named Fareed Miller Jr., who will offer family support. They want to come get Keith and make sure he stays out of trouble and provide him with support, as well as making sure he has everything set up with disability and all of that. He will also be given a job at a dock building company in North Carolina. Mr. Miller has no other support in Atlanta, and so we've done our best to set it up so that as soon as he's released, his brother will come and get him and ensure that he has the support he needs.
Okay. What, do we have any history, pre-trial? Mr. Miller?
Yes, Your Honor. Looks like the defendant is a multi-state offender. He has 35 arrest cycles out of Georgia and nine cycles out of North Carolina. He has at least 1, 2, 3, 4, 5 violations of probation within the last 10 years. He has 1, 3 felony convictions within the last 10 years. The first one is for terroristic threats out of Gwinnett County. Disposition date on that is January 2014. Another case out of Gwinnett County, same disposition date, January 2014. Criminal damage to property in the 2nd degree, simple battery. He has another case out of Douglas County for identity theft fraud when using, possessing, identifying info concerning a person. Disposition date on that is May 2016. And nothing to add on any history within the last 10 years, Your Honor.
And Your Honor, I will, just to add on, I understand he had prior cycles in North Carolina. I'm not sure if we got any convictions on that, but I did, when I spoke with Mr. Miller, his brother, they mentioned the dock working business is on a secluded lake, which they thought would be, in the best interest to make sure that they can ensure that Mr. Miller gets the support he needs while being away from areas that could pose problems.
Your Honor, his North Carolina history, the last thing was from 2003. Okay. So nothing within the last 10 years either there.
Okay. All right, Mr. Miller, I'll give you one more chance, one last chance to be on probation. You gotta report and do what they ask of you to do. Understood?
Sir, ma'am, I'm sorry, ma'am.
Yes, I'm gonna give you one more chance with probation. But you've got to report and follow the instructions and follow the conditions. Can you do that?
Yes, ma'am.
Okay. All right. So that's what I'm going to do. I won't revoke you today, but you've got to get there and get reporting. All right. These cases. Not going to be revoked. Okay.
Thank you, ma'am.
All right.
Mr. Miller, make sure you report immediately, okay?
Yes, sir.
Okay, Ms. Harris, I'll send the paperwork as soon as I.
Positions 39 and 40.
Attorney McLean is still talking with his client who needs the translator on, so we'd have to hold on 39.
All right.
We can go to position 31 and 32. Mr. Pinckney.
All right, Mr. Pinckney.
Good morning.
Good morning. This is 23 CR 002048Y. You're charged with 1 count of criminal trespass and damage to property on October the 18th, 2022. And then you have a second case, 22 CR 001338Y, where you're charged with 1 count of simple battery family violence on December 27th, 2001. State.
Yes, Your Honor. So on position 31, the state's offer is 12 months to serve, 60 days, credit for time served, 30 days, balance probated to a 6-week anger management course. No further contact with the victims. Last names are Thomas and Braxton. Their first name is Sanai Thomas or Kanai Thomas. That's CANAI. And then Braxton is Micaiah, and that's MYKIA, Braxton. And to stay away from 2900 Camp Creek Parkway, apartment M12. For position 32, the state's offer is 12 months to serve, 60 days, credit for time served, 30 days, balance probated with a FVIB, no further contact with victim Kanai Thomas, the same one in the previous case. and to stay away from the address 2075 Brent Creek Way.
Okay. That's your understanding, Mr. Dodd? I'm sorry, Ms. McLeod.
Yes, Your Honor. My client is to be arraigned, Your Honor. I have discussed the state's plea offer with him, and he wants to have a trial.
Okay.
And we would also ask whether or not my client could get a signature bond, Your Honor, on these cases.
All right, pre-trial. Yes, well,
Mr. Honor, looks like the defendant has 7 cycles out of Georgia. It appears he has only 1 FTA. He currently has 2 other open cases, 2 CP cases, 23 CP 217-415 for willful obstruction of law enforcement officer and purchase, possession, manufacture, distribution, or sale of marijuana. The other case is 23 CP 217-417, robbery by sudden snatching, theft by taking, and criminal damage to property in the 2nd degree. And it looks like his last arrest was April 2nd, 2023 for possession of a Schedule II, 1 or 2 controlled substance and willful obstruction. I'm not sure what is happening with that case because it's not listed in Odyssey, but it looks like he was arrested by East Point Police and there's no other disposition listed on the GCIC. Nothing to add, Your Honor.
You know, my client, my understanding is that he has no convictions on his record.
That's correct, Your Honor, no convictions.
Okay. All right, Ms. McLeod, you may proceed.
Your Honor, my client has been sitting in jail for well over 30 days. He has not been able to make bond. Having a signature bond would be helpful, Your Honor, for him to get out of jail and be able to mount a defense against these charges. It is more difficult for him to defend against these charges when he's sitting in jail. So we would ask, given the nature of the case, the allegations, the time when these events are alleged to have occurred, that a signature bond would be in order.
What's the bond currently?
I'm sorry, Your Honor.
What's the current bond?
The current bond is a $1,000 good bond, I believe.
There's a lot of feedback. 1,000 good bond on the criminal trespass, damage to property. And then the second case, simple battery, family violence.
It's a $5,000 surety bond on that case, Your Honor.
Okay. All right, and a 5,000 surety.
Yes, Your Honor.
Yeah, the defendant does have 2 holds. He has 1 hold for Clayton County and Douglas County.
Okay. All right, in the first case, the criminal trespass ending in 2048Y, I'm going to leave that bond at 1,000 surety. That will remain the same. And then the second case ending in 1338Y with the simple battery, family violence. I will reduce that bond to a $3,000 surety bond.
Thank you, Your Honor.
All right, thank you.
Your Honor, my client was supposed to have been arraigned last week, but he was ill. He was at the hospital, but he is available today and needs to be arraigned.
On both cases?
Yes, Your Honor.
All right. Do you waive formal reading of the accusation?
I do, Your Honor.
All right. Mr. Pinckney? Can you hear me?
Yes, ma'am.
All right, we're going to arraign you on both cases today. The case ending in 2048Y, you're charged with 1 count of criminal trespass and damage to property. And you understand that you've been charged with this case by the Solicitor General's office in Fulton County. And this charge carries a maximum sentence of 1 year in jail or a maximum fine of $1,000. At the trial, you will have a right to an attorney. And again, the state has the burden of proof at the trial. And they will be represented by the Solicitor General's office. They will bear that burden and will have to convince a jury beyond a reasonable doubt in order to get a conviction in this case. If they do get a conviction, again, the maximum sentence would be 1 year in prison or a fine of $1,000 for each of the charges. Based on the information, how do you plead to criminal trespass and damage to property?
Not guilty.
How do you plead to simple battery, family violence?
Not guilty.
All right, and both charges would carry a prison sentence of 1 year in jail, 1 year in prison rather, or up to $1,000 fine, okay?
Yes, ma'am.
All right. You have been formally arraigned on both cases.
Thank you, Your Honor.
All
Your-
right, thank you.
That concludes my business before the court today. May I be excused?
Yes, you may. All right. Have a good one.
You too.
Position 39 and 40.
$39 and $40. Is that Mr. Strotter?
Yes, ma'am.
What do we do? We were holding on 39 and 40. What's the announcement?
Yes, Your Honor. Attorney McLean is still on the phone with the interpreter on the other position.
Oh, he's still on the phone?
Yes,
With
Your
the
Honor.
interpreter? We're still holding for 39 and 40. The attorney's still on the phone.
Mr. Dodas? I have your client here, Miss Position 17 and 18.
Okay, we can take ACDC clients, if that's all right.
Come on, Miss April Harris. I'm sorry, Trina Jordan. She's position 22.
All right.
Miss Jordan.
All right, this is 23 CR 002376J. Trina Jordan, charged with 1 count of criminal trespass. The offense date is 4/16/2023. Is this going to be a plea?
Yes, Your Honor. This is going to be a non-negotiated plea at this point.
Okay,
Jail time is the only term at issue.
okay.
What position is this? I'm sorry.
22. Trina Jordan. All right, I understand this is a non-negotiated plea.
Yes, Your Honor.
All right, this is 23 CR 002376J. Ms. Jordan, you're charged with 1 count criminal trespass. The offense date is 4/16/2023. State?
Yes, Your Honor. So This incident occurred on April 16th at 4,000 Campbellton Road, where officers arrived in response to a possible burglary. The victim in this case, Mr. Eric Hayden, advised officers that he saw the defendant climbing into his window through his Ring camera, Your Honor. Mr. Hayden was able to give our office the estimated damages of his window, which totaled $738. And so we'll be asking for that amount in restitution. So our offer would be 12 months to serve, 120 days, credit for time served, 16 days, balance suspended to stay away from Mr. Eric Hayden's address at 4,000 Campbellton Road, as well as pay the restitution amount for the window damage, which is $738.
All right, is that your understanding, Mr. Dotis?
Your Honor, that was not my understanding of the offer. There was no mention of restitution, and the charge is just criminal trespass. I don't have any information on any restitution or even any damage mentioned in the report.
Mr. Dotis, I can email you over the paperwork that Mr. Hayden sent us where he went and got an estimate for his window.
If I could chime in, Your Honor.
Yeah.
So it's a non-negotiated plea, so the state can change his offer at any time. The victim in this case, he was traveling at the time that we contacted him. As you know, these calendars are only published about 5 days ahead of time. He literally just got off the plane and sent us this email a few minutes ago. So that's the reason for the updated offer. And since it is non-negotiated, the state can change his offer, and we are asking for the restitution. I believe Ms. Bickerstaff has some type of documentation if council would like to review it.
The window was open.
Ms. Jordan, please stop talking.
Yes, sir.
Yes, Your Honor, I understand that the state can revise their offers. Again, I need to speak with my client. Based on the information I had and what she's been charged with at this point, I just have it as a criminal trespass. If it's a damage to property, then I need to speak with my client, and see where we're going from here.
Would you call your sister?
Okay. That's my litigation manager. Do you just have criminal trespass as well on position 22? Yeah, okay. So we don't have the criminal damage to property as the charge.
And he can't.
State and
I mean, I'm of the opinion of, irrespective to what the charge is, if damage was done and the victim's asking for it, I want to ask for it. I mean, restitution can be ordered in battery cases, so it doesn't have to necessarily be a criminal trespass damage. I mean, the state can absolutely amend it to a criminal trespass damage. But I think irrespective to what the charge is, the victim is stating that this damage was done to the property, and we are asking for that amount in restitution. I believe, albeit we just got it a few minutes ago, we do have the documentation or some sort of documentation in regards to the damage.
okay. Mr. Dotis?
Your Honor, I need to look at that again. As I stated, based on the discovery I have, there was just a criminal trespass alleged. I don't see anything in the report of a damaged window. So without knowing more, I can't, I need to speak with my client, number one, but I don't know if I can go forward with a plea on restitution when I don't have any information on that.
All right. Is there anything that you would like to send over, ASG Bickerstaff on the?
Yes, Your Honor. I'm sending over the quote to PD Dotis now.
And I think if we could maybe hold on this position while she sends that, I know there's some other clients at ACDC we might be able to take.
Okay, we'll hold and come back. Deputy, do we have someone we can put in place? We're holding on, Jordan until the, information gets to our attorney. Who we have in 3 South?
I believe that's a position for Attorney McLean, who's still speaking with the translator. I know I have one more client at ACDC if Officer Milton is there.
Okay, we're still waiting.
¿Sí, cuánto desde que un mes? Un mes más los apuestos, más de lo que tengo ahorita aquí.
Looks like we're in a hold pattern for a moment.
Sí, estamos ahora. Pero estás seguro de que sí no va a ser mejor. Sí, por favor.
This judge is very reasonable.
Sí, And Your Honor, both of our office phones are in use for the translator. Is there anyone at the courthouse that could call ACDC to see if we could get Officer Milton to answer? I just hate to just be waiting here.
All right, I think we're gonna see if Mr. Jordan can. Oh, he didn't have their phone number?
Can you call my attorney for me again? Try it really.
Mhm. Great. Do we have someone else coming on?
21,
Right, who do
Mr.
you-
Johnson.
Mr. Johnson? Whose case is that, Mr. Dotis?
And Your Honor, this is my case. I will need a breakout room with Mr. Johnson if we want to do that now with my laptop. They were unable to locate Mr. Johnson, so I do need to discuss this case with him.
Yes, please.
So if my laptop is PD Angelo Dotis, I'm starting the video. If someone could just put me in jail court's iPhone in a breakout room, I'll step out.
Okay.
Mr. Dotus? Courtroom 2?
He stepped out there.
Okay, thank you.
Thank you, Your Honor. We are ready on position 21. That'll be a negotiated plea.
Okay. This is 23 CR 002466H. Is it Materius Johnson? Or Martirius? Not sure if I'm pronouncing. I'm sorry. Say that again.
Yes. Yes. You're correct.
I'm correct. We've got a kind of bad connection. It's. Say something again, Mr. Johnson. Just say hello. Let's see.
I'm saying I can hear you. That's my name. I was just saying I can verbally hear you. It's me.
Right. We can barely, I'm getting kind of every other word from you. The deputy near you?
Yes, I am, Your Honor.
Okay, I can hear you better than the defendant. I was getting every other word.
Just try to speak loud, okay?
Okay. All right, then I can hear you better. You're being charged with 1 count of criminal trespass, 1 count of simple assault from April the 16th, 2023, see offense date. Do we want to, so this is going to be a negotiated plea?
That's my understanding, Your Honor.
Okay.
Yes, Your Honor.
All right, state, tell me what we have.
Yes, the state's recommendation is 12 months to serve, 28 days, credit for time served, 14 days, balance probated with the conditions of an 8-week anger management course, no further contact with the victims of Vernette Williams and an Elder Stanley, and a stay away from the incident location, which is 1311 Cleveland Avenue.
Okay. All right, is that your understanding, Mr. Dotis?
Yes, Your Honor, that's our understanding. We do stipulate to the factual basis, venue, and ID for the purpose of this plea. We would request Mr. Johnson switch to non-reporting status upon completion of the 8 weeks of anger management. Additionally, if Your Honor could help Mr. Johnson out with his probation fees, he has informed me that he will be residentially challenged. And so to ensure that he's able to meet his probation obligations and pay for anger management, we would request a break on a few months of probation fees.
I won't be able to waive any of the probation fees at this time. And hopefully you all can help Mr. Johnson with his residential status with some resources to help him out.
Understood, Your Honor.
All right. And so, Mr. Johnson, are you ready to take your plea?
Yes.
Okay.
Yes.
Yes. Okay, raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury? Okay, put your hand down for me. I'm gonna ask you a series of questions in order to accept your plea. Are you under the influence of any medication, drugs, or alcohol at this time?
No.
Are you satisfied with the services and representation of your attorney?
Yes.
Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes,
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
yes,
And that you agree to give up and waive these rights today, is that correct?
yes,
Has anyone told you that you'll receive a lesser sentence for pleading guilty? Has anyone promised you anything to plead guilty?
I mean, I just heard that I'd be released in 24 hours to serve anger management. Yes,
Okay, that's part of your plea. They've not promised you anything beyond that, correct?
no,
Okay, and do you understand that if you're currently on probation, it could affect your probation or it could be revoked because of your guilty plea today?
yes,
All right, and so do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
repeat what you just said again.
Do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes,
Okay, all right, so I will accept your negotiated plea. And remember that your balance of your probation, you will have to serve that until you complete the 8 weeks of anger management. And then you'd have no further contact with Burnett Williams and was it Elder? Don't remember the last name. Was it Stately or Stanley?
Stanley.
Stanley. And you're to stay away from 1311.
So what?
Huh? You'd have no further contact with
What-
Burnett
what-
Williams and
okay.
Elder Stanley.
This is the question. When I'm released tomorrow, how do I find out my anger management? Where do I go?
When you report to probation, they will give you that. When you
No, I
report to
don't-
Right, when you report to
I gotta-
probation, they will give you that information.
Right, and Your Honor, I know that we had some connection issues, but I
Yeah.
thought we did get through the plea. He understood everything when I spoke with him, but we did have connection issues, but he was clear. And I'm gonna send a paperwork with probation's number. He knows the first thing he needs to do is to call.
Okay, all right, we will accept his plea.
Thank you, Your Honor.
All right, thank you. Oh, there he comes back. Mr. Johnson? You're muted. All right, so I have accepted your plea, and when you report to probation, they will give you the information on your anger management course. And I'll let you go non-reporting after you complete that, okay?
I understand.
All right, good luck to you.
Thank you.
All right.
Are we ready for position 39 and 40 now?
Whoever lives 34, 35, Mr. Roman.
All right, 39 and 40. Let's see. Oh, that's Mr. Cedric Strouder. Okay, that's you there, 3 South. All right, we were holding, what's the announcement? Are these arraignments or pleas? Mr. McLean?
Oh, wait a minute. Okay, we're off mute. Your Honor, Cicely Smith is a probation matter. Mr. Roman Hurtado, it's a hyphenated last name, is a plea. It's going to be an.
Hold on a second, Mr. McLean. You're going a little fast for me. You said the first case was Smith?
If, right, Cicely Smith, I understand, is at ACDC, and she is simply a probation revocation case in which my understanding is that they're going to recommend time served, so that will be quick and simple.
Thank you.
Okay, so on position 7 on the probation revocation, they're recommending time service probation there? Probation?
Yes, Your Honor, I do apologize. You wanted probation or intake?
Probation, I'm sorry.
Okay, I'm sorry.
Yes, Your
Uh,
Honor,
so-
what time serving Mr. Smith?
Okay, all right, so that one's finished. That's a time served, okay.
Right.
I have that. And then what was the next one?
That's the kind of thing where it almost doesn't require her consent. It's just her acknowledgement of what she gets. And that's, thank you, Your Honor. So Mr. Roman Hurtado has one case of public drunk, one count, and he has a failure to appear. I'm going to put this up, Your Honor, as an unnegotiated plea. It'll be an unusual situation, and I'll explain.
Is this the one with this is position 35?
Yes, Your Honor, 34, 35 with the interpreter. He has no English whatsoever.
Okay. Yeah, this is the one. So this is going to be a non-negotiated plea?
Correct.
Okay. All right, and let me ask this, on probation, have we finished all your cases?
Yes, Your Honor.
I think we have.
We have.
Okay. All right, thank you so much.
You're welcome. And how long you be in the courtroom, Your Honor? Because I have to bring in the stuff for you to sign once the PD send me the petitions.
I'll be here as of Mr. McLean, but I'll still be here.
How long will you be there, Your Honor? Because I know once you all leave, you leave for the day.
I have to do C today at 2 o'clock, so I may end up doing it here if I don't have enough time to go virtual. So we'll at least be here to 12-ish. I'm looking at Ms. Strong. Probably 12:15, 12:30. Can you make it then?
Hopefully the PDs can give me this stuff before then, before you leave, because I have Judge Porter at 1:30, so I wanted to catch you before you left the courtroom.
Yeah, well, I think I may stay down here to do C at 2 o'clock. So I may still be here.
If you can't,
not, check with Mr. Jordan, and he can tell you where I am.
Okay, all right, thank you, Your Honor.
Thank you. All right, thank you.
Position 39 and 40.
Uh-huh. What about them?
Are we finished with position 39 and 40 on 3 South?
I was holding on that case. Mr. McLean, before we start with 34, 35, can you tell me about 39 and 40, Mr. Strouder?
Oh, that's just a not guilty, Your Honor. And we do have bond request. Thank you.
Are you asking me to take Mr. Strouder before Mr. Roman?
Whatever the court's pleasure, Your Honor. Mr. Strouder is definitely a not guilty, and I'll state where he's going to live and make a bond request.
Okay. Deputies, which one would you like me to do first?
39 and 40, so I can leave, come down and help the interview.
Okay. All right. Let's go over to Mr. Strouder. Raise your hand for me, Mr. Strouder. Okay. Making sure you can hear me. All right. This is positions 39 and 40, 21 CR 006213J. You're charged with 1 count of criminal trespass. Offense date 11/9/2021. And position 40 is 23 FTA 000334. And again, offense date is 2/21/2023. So that's a no cross if we were to accept the guilty plea on 39. And so what are we doing?
Your Honor, he waives formal reading of the accusation. It's 1 count of criminal trespass and also a separate count of separate case of failure to appear for fingerprintable charge. I've explained to him that those are misdemeanors. What the sentences could possibly be if he were to lose a trial. And my bond request, Your Honor, you want me to go ahead and segue into that or just do the arraignment first?
Let me hear from the state.
No.
Yes, Your Honor. So in position 39, this incident occurred November 9th, 2021 at 1074 Ponce de Leon Avenue. And this is where Officer Richardson was getting off work and going home, and the defendant walked up to the officer's personal vehicle and began hitting the window shield. The car sustained 2 chips in its window shield, causing about $500 in damages. Your Honor. For this reason, the state's offer is 12 months to serve 42 days, credit for time served 21 days. The balance is probated to a MHET.
All right. Is that your understanding, Mr. McLean?
It is, Your Honor.
Okay. All right, Mr. Strouder, you wish to plead guilty to criminal trespass? I'm sorry, this is an arraignment, correct?
Right.
I'm sorry. So you're pleading not guilty, and by explaining, you're waiving formal reading, correct?
Strouder, how are you pleading? Mr.
You're pleading, Mr. Strouder, how are you pleading to the charge of criminal trespass?
Not guilty.
Okay, and so you're waiving formal reading, is that correct, Mr. McLean?
Yes, Your Honor.
Okay, and so you've been charged with 1 count of criminal trespass, as well as the failure to appear for fingerprintable charge. And as far as those charges, the Solicitor General of Fulton County has already accused these cases. And the maximum sentence of 1 year in jail or maximum fine of $1,000 for each of those charges. This case will be reset for a jury trial, and the trial will be scheduled by the state court judge to whom the case is assigned. All right, so you've been formally arraigned.
Now, on the booking sheet, Your Honor, the booking sheet oftentimes on situations like this has the big bond or the problematic bond is oftentimes on the failure to appear itself. So whatever the booking sheet shows for 39, 1 count of criminal trespass, whatever the bond is there, which I believe I was trying to look it up, but the failure to appear bond on case number 40, which has its own separate case number, both of those cases together, Your Honor, let me put it this way. He is asking for a signature bond for this reason. He can work. He has a history of working. He worked for several months for Arby's. He worked for 2 years at Walmart, and he worked for several months, I'm not sure the duration, at the hospital, the main hospital in Macon, which is called Navison. He is from Macon. His people are in Macon. His mother's in Macon. His aunt is in Macon. And he will find a job in Macon, which he feels very confident he can do because he's had so many jobs there before. And he's had jobs, depending on the economy, he's had jobs that were very steady for him. Your Honor, he will live. I spoke on the phone with his mother, and I confirmed that she believes that it is correct that his aunt, her sister, which is Carolyn Glenn, I don't think I caught the mother's name, but the mother did tell me that his aunt, her sister, Carolyn Glenn, who lives on Telfair Street, and I do have the actual house number, we got the actual address, will take him in, and there won't be a problem. I also spoke on the phone with his mentor. He has a mentor. He has a personal development mentor because of the situation in Macon. The family's helping him look out after his life. And his mentor is named Cordell. I believe that may be his last name. And he told me that he was familiar with the family, that the aunt would take in Mr. Cedric Strouder, and that he believed he could get a job and pay attention to his mail and not miss court dates. So for those reasons, Your Honor, job availability, housing stability available through the family, those are the 2 main reasons why we'd asked the court to trust him with a signature bond to come the 90 miles to Atlanta whenever he needs to.
All right, there's no prison bond set, is that correct?
So I'm not sure about what the exact bond is right now.
There's a bond set, Your Honor. Just
Yes, so for position 40, the FTA, there's a $2,000 surety bond where the defendant missed the court date on February 21st of this year.
Okay.
He was in another county jail at that time. He could not have made bond, but I don't have proof of that, but his mother said that was correct. I have no written proof.
If he would bring that proof, or you would send that proof over. And then on position 39, what's the state's bond recommendation? Or do we need to hear from pretrial?
The current bond on position 39, is a $1,000 signature bond through the jail.
Oh, but he defaulted on that, correct?
Correct.
So I'm not inclined to give him another signature bond.
Right, like, as I say, I have, because we just, got the case and talked to him yesterday, I have no way of proving about the Cobb County incarceration on February 21st, unless I were to have.
I have the proof with me here.
You have the paper with you?
Yes, ma'am. All the papers, yes, ma'am. And my property here in Fulton County.
Your property is not with you, sir. Your property is not physically in yourself.
No, I
Property is in a bin somewhere in a trust fund.
I still have it with me. I still got it with me.
Okay.
Your Honor, sorry to
Mr.
interrupt.
Walker,
It's my understanding that it started as a signature bond. I understand the defense is saying that his client was locked up. We don't have the proof of incarceration. Typically what the court does when someone's being held on an FTA, they send it back to the division judge that issued the bench warrant. So in this case, I asked the court to do the same exact thing. If counsel can produce a proof of incarceration prior to that, I'll be glad to take a review and perhaps consider a consent bond. But at this time, we're asking that it's sent back to the division judge who issued the initial bench warrant on the FTA.
right.
I don't know how fast we can get those proofs, but I do.
As fast as you can call that jail, ask to have them email it to you.
But we're just going with what we got today with.
Which is nothing.
There's an expression in motorcycle racing where you run what you brought.
Nothing's further from the state.
I know, I'm looking at Mr. Walker. We don't have anything today. Let's see. I certainly will not entertain that. And Mr. Walker, on the criminal trespass, I'm sending it back to the division judge. So it's just going to be held on the $2,000 surety for position 40. Am I setting a new bond on 39, or it will just revert back with the FTA?
It will revert back to the FTA.
Okay, that's what I was making sure. All right, that's what I'm going to do. Mr. McLean, if you can get that information back to, which judge is this case assigned to?
Let's see, it's a J, that would be Judge Diane Besson.
Okay. So
I'll get in touch with the division public defenders and have them get to work, because I'll be working on the next SAP.
okay, that'll be fine. Thank you.
Thank you for consideration, Your Honor.
Okay.
That's all we have on Mr. Strouder at this time.
Okay. All right, Mr. Strouder, your case will be referred back to the division judge. Who do we have next?
I'll call your mom, Mr. Strouder.
Position number 34, 35, Mr. Roman.
I'm sorry?
Position number 34 and 35.
Okay.
Mr. Roman.
All right, I'll swear in the interpreter. Raise your right hand for me. Do you solemnly swear or affirm that you will faithfully interpret? And I did not ask, is it Spanish to English, English to Spanish?
Yes, Your Honor.
The proceedings before the court in an accurate manner to the best of your skill and knowledge with no embellishments?
I do, Your Honor.
All right, thank you. This is position 34, 22 CR 003842A.
Esta es la posición 34-22CR-003-842A.
And this is State versus Leonel Roman Hurtado.
Esta es la fiscalía en contra del señor Leonel Roman Hurtado por el cargo de ebriedad en público.
And that was offense date June 15, 2022.
Ocurrido el 6 de junio del 2022.
And then I have case number 23 FTA 000342.
Y también tengo el caso 23 FTA 000342.
Failure to appear on September the 8th, 2022.
Por falta de comparecencia el 8 de septiembre del 2022.
Okay. Stay.
Yes.
I'm sorry, are these pleas or not?
¿Es una declaración o no?
Yes, Your Honor, unnegotiated plea.
Sí, no negociada, su señoría.
All right, do you want to hear from pretrial first?
¿Quiere escuchar por los servicios previos al juicio primero?
ASG Bickerstaff, do you want to hear from pretrial
Yes,
first?
I'm sorry. Yes, we can hear from pretrial first.
Sí,
Okay.
podemos escucharla.
Go ahead,
Your Honor.
pretrial.
Yeah, the defendant has 4 arrest cycles out of Georgia.
El acusado tiene 4 arrestos, ciclos de arrestos en Georgia,
With 1 misdemeanor conviction outside of the 10-year period.
con un delito menor fuera de un periodo de 10 años.
And we have 1 misdemeanor conviction out of Fulton County for giving false name.
Y también un delito menor en el condado de Fulton por dar un nombre falso.
Simple assault, family violence, disposition date on that is February 2013.
Y también golpes y lesiones, violencia familiar, el 20 de febrero del 2013.
1 violation of probation and 1 FTA. Nothing to add.
Un incumplimiento de probatoria y una incomparecencia.
Okay. All right, thank you. State.
Yes, so this incident occurred 6/15/2022 in the Forest, it's off of Forest Street in the common alleyway.
Esto ocurrió el 15 de junio del 2022 en Forest Street, en un callejón.
And this is where officers 20 minutes before arresting the defendant, an officer gave the defendant a warning about drinking about a block away from the incident location.
20 minutos antes la policía le notificó, le avisó al acusado de no alcoholizarse y también le dijo que se retirara del lugar en donde estaba.
Yes, and so 20 minutes later, the defendant was spotted passed out on the sidewalk with suspected urine and feces and bleach on him.
Y 20 minutos después se lo vio a este acusado tirado en la calle, desmayado y todo orinado y con materia fecal encima.
Yeah, so for these reasons, the state offers 12 months to serve 32 days, credit for time served 16 days, the balance probated, and an ADET.
ADET. Could you please help the interpreter? Acronyms don't work very well in
I'm
Spanish.
sorry, it's alcohol and drug evaluation and treatment.
Thank you, madam. Entonces la fiscalía recomienda 12 meses de probatoria con 32 días a servir, crédito por el tiempo servido y 16 días que ha servido. Y también recibir una evaluación de drogas y alcohol y tratamiento si es requerido.
All right. And so, Mr. McLean, is that your understanding of the plea offer?
Señor McLean, ¿esto es lo que usted entiende del convenio declaratorio?
Yes, Your Honor. Yes, Your Honor.
Sí, sí, su señoría.
All right. And so we're ready to take the plea?
¿Estamos listos para tomar la declaración?
And I'll explain why I'm making it a unnegotiated plea, Your Honor.
Quisiera explicar por qué esto es una declaración no negociada, su señoría.
Would you like me to do that first or have him?
Yes, go ahead and do that first.
Okay. Your Honor, this is just a heartbreaking situation. It makes you want to cry. It is.
Esta es una situación realmente muy dolorosa que lo hace a uno querer llorar.
The probation would be a great idea if we thought he could do the probation.
La probatoria, una sentencia de probatoria sería ideal si él pudiera cumplirla.
But I've asked him about his contacts with people, and he has a sister who works very hard at her landscaping job and is available by telephone after 7 p.m.
Yo le pedí acerca de los contactos con personas que él tenía y tiene una hermana que trabaja muy fuertemente en el paisajismo y ella está disponible después de las 7 de la tarde por teléfono.
And I said, you know, if you're residentially challenged, which apparently he is, and has only the ability to do probation by checking with his sister for mail and probation messages every day.
Yo le pregunté si él tenía problemas con obtener una residencia y sí los tiene, por eso yo también me quise saber si él podía chequear con la hermana todos los días por teléfono y por llegada de correspondencia.
And he's certainly willing to do that, but the evaluation has a cost and he has no money.
Él está dispuesto a hacer esto, pero la evaluación tiene un costo y él no tiene dinero.
And that brings us closer to the main point, which is an alcohol evaluation is really superfluous. He has an alcohol problem.
Esto nos trae al punto principal, que una evaluación nos trae a detectar un problema de alcohol y él tiene un problema de alcoholismo.
And he has an incentive with or without probation, which we don't believe he can do probation, but he has a great incentive to get alcohol treatment because he has cirrhosis, and this will kill him if he doesn't.
Pero él tiene un fuerte incentivo, reciba o no una sentencia de probatoria, que en realidad no puede cumplir. Él quiere de todas maneras recibir tratamiento porque padece de cirrosis. Entonces, él tiene que ir a tratamiento para poder vivir.
He told me he went to some place in Kennesaw and they provided some treatment, but could not provide any further treatment or medicine. And for that reason, the problem is that his sister, who has the great job, and he could check with her every day, but she's in Woodstock.
También él me explicó de que él fue a Kennesaw, donde recibió tratamiento y medicamentos, pero no pudieron darle más de eso. Y también él tiene su hermana en donde él podría ir y recibir correspondencia o tenerla como contacto, pero ella vive en Woodstock.
So as a practical matter, if he's going to be homeless or residentially challenged to be the preferred term in the Roswell area, that's not going to work as a lifestyle. They'll be constantly arresting him.
Y le expliqué que si él va a continuar siendo desamparado en Roswell, no va a funcionar porque él puede ser arrestado nuevamente.
To continue to live, he needs to be in downtown Atlanta at a shelter.
Para poder él continuar viviendo, él tiene que estar en el centro de Atlanta para vivir en un refugio.
And he doesn't need probation as an incentive to do that. He's going to die if he doesn't treat his cirrhosis.
Y no necesita la probatoria como un incentivo para cumplir su sentencia, porque él va a morir debido a su cirrosis.
Woodstock is way out there. Kennesaw is way out in another direction. His only hope of living is to come to Grady, because that's the hospital where they will give him medicine, whether he can pay or not.
Lo que Woodstock y Kennesaw están totalmente alejados y muy apartados de donde él puede estar. Entonces, la única esperanza, le expliqué, que tiene es ir al Hospital Grady, en donde él puede recibir tratamiento y medicamento, así él pueda pagar o no.
I don't mean any disrespect to any public hospital in another county, but if he is residentially challenged in Fulton County, I can understand that other public hospitals are not going to take him on as a responsibility. And his best shot at living, his best shot for survival is to come to Grady.
Yo no quiero faltarle el respeto a ninguna otra hospital perteneciente a otro condado, pero no, si ahora mismo a él le cuesta recibir ayuda médica, va a ser más difícil obtenerlo en otras áreas. Y si él quiere intentar sobrevivir con su condición, la opción de él es Grady.
So that's the desperate situation, that's why I said it's just heartbreaking.
Por eso, esta es la situación, su señoría, que yo, como le había nombrado, es muy dolorosa.
We would ask the court to consider giving him time served either today or in a week or 2 or 3 at most, if possible. We would promise to make a referral to PAD, and we would promise to get a social worker to give him a list of everything we can think of, but the main thing is Grady.
Nosotros le pedimos a su señoría que le otorgue tiempo servido ahora, o en una semana, o 2 o 3, pero nosotros le prometemos que vamos a derivarlo a un tratamiento médico, a obtenerle una trabajadora social para que él pueda recibir toda la ayuda posible y guía y obtener su tratamiento, y la única posibilidad es Grady en este momento.
Oh, and I asked him where the diagnosis was from, and he said that was from the Kennesaw Hospital.
Yo le pregunté de dónde vino el diagnóstico de cirrosis y él contestó que de Kennesaw.
Well, he has a little history that's a little concerning to me.
Él tiene un historial que me preocupa.
And you're requesting a time served, please?
A time
¿Y
served,
usted pide tiempo servido? Tiempo servido.
and what I'm saying is that I think his incentive to follow whatever referrals our social worker can give him.
Queremos darle un intensivo y que él siga todas las condiciones y guías de la trabajadora social.
His incentives to get his treatment are based on his condition medically and are stronger incentives than we can think of for probation that I think would fail.
Pero, o sea, la única manera de conseguir él un incentivo a obtener su tratamiento sería de esta manera, que darle una sentencia de probatoria en la que yo estoy convencido que él no va a poder cumplir.
Does the state have a response to that?
¿Cómo responde la fiscalía?
Your Honor,
Su señoría.
I think that the public defenders we want the defendant to do the ADET, and that's my concern. The state wants to give him a time served, but on the condition that he gets the ADET, considering that Mr. McLean let the court know that the defendant has a medical condition dealing with alcohol. The state thinks it's very important that he figures out how he can do the alcohol evaluation and treatment.
Su señoría, nosotros queremos que se haga la evaluación y tratamiento de alcoholismo, debido a que el señor abogado comunicó la condición médica que el acusado tiene. Por eso la fiscalía considera muy importante de que él aprenda o reciba la confirmación de su alcoholismo y que también el tratamiento para el alcoholismo.
I was just saying to him, when I speak of the cost of the evaluation, he's saying, well, within a couple of weeks, I can get a job. And I'm thinking, you know, you just need to get to the hospital.
Bueno, cuando hablé sobre la evaluación, él me dijo, necesito encontrar trabajo y esa es la base por la que yo opiné.
Does he have a driver's license?
¿Tiene una licencia de conducir?
He does not have any ID card. He lost it. That was how many weeks ago?
Él lo perdió a su identificación. ¿Cuántas semanas atrás?
How long ago did you lose your driver's license?
¿Cuánto hace que perdió su identificación?
ID card.
No, ya tiene como 7 años.
7 years ago.
Right.
7 years ago?
7 años atrás, señor? Yes.
So I'm just thinking Grady's the type of very big city hospital that understands and sees more of these problems and will simply treat him.
Yo creo que Grady es un hospital muy importante de una gran ciudad y está disponible para ofrecer tratamiento en esta situación.
But he has no ID, no driver's license. So I don't understand how he's going to get to work. Somebody's going to take him.
Él no tiene identificación, entonces no entiendo cómo él puede obtener trabajo. ¿Hay alguien que lo pueda ayudar a trabajar?
I'm sorry, what was the question?
How is he going to get to work?
I don't think his work plans are realistic, Your Honor. But if he stays in the Roswell area and doesn't get picked up for any type of offenses related to his homelessness, that I think he's talking about walking to work.
Yo en realidad no creo que es una opinión realista de él, pero si él va a ser arrestado por ser desamparado, creo que la opción que tiene es caminar para llegar al trabajo.
I've seen myself, there is a lot of construction going on in North Fulton and there are jobs available.
Hay mucho trabajo de construcción en Roswell, eso es lo que yo veo.
But he has no ID.
Él no tiene identificación.
I just don't see how letting him do time served or giving him a time served plea and he doesn't have ID, doesn't have anything to be able to, you know, get to work or I don't know, even with this ADET.
Yo no veo cómo él puede dársele tiempo servido si no tiene identificación y también imponerle un tratamiento de alcohol.
My thought would be just to refer him to PAD.
Refer him to where, sir?
I'm sorry, PAD. What does that stand for? It's an acronym. Public something, I'm not sure what PAD stands for, but it's a program for people who are in desperate need of homelessness, residential challenge services, they need shelter, they need other social services. And among other things, they'll try to get them an ID.
Yo creo que él podría ser un candidato para los servicios que asisten a desamparados y quizás le puedan dar una identificación.
I'm not so sure about the success of him being in that program.
Yo no estoy segura que él cumpla con éxito al estar en este programa.
Does the state have any other suggestions or any, I mean, what's the state's opinion?
¿Cuál es la opinión de la fiscalía?
I'm thinking, you mentioned Mr. McClain about his sister. Maybe does he have any other family support that can aid him with going to the treatments?
Señor McClain, usted mencionó a la hermana. ¿Hay alguien más que pueda ayudarlo para él cumplir el programa?
Let's ask him directly through the interpreter. Sir, have, besides your sister in Woodstock, do you have any other family or close friends that can help with your transportation?
Señor, Aparte de su hermana que vive en Woodstock, ¿hay algún otro amigo o familiar que pueda asistirlo en llevarlo a sus tratamientos o donde usted necesite?
No.
No.
My hands are tied, but I don't feel safe about letting this defendant out to then lose him again or he not obviously have the resources that he needs, but
En realidad tengo las manos atadas, pero no estoy dispuesta a soltarlo para que él vuelva a cometer el misma delito de nuevo y ver que, o sea, y no pueda tampoco recibir tratamiento.
Your Honor, if Your Honor feels more comfortable with resetting the case either to Thursday or next Tuesday, I will certainly have the social worker try to get the correct language, access to him, and see if we can find out anything more about possible resources. But I don't think it's going to be from family.
Si su señoría se siente más cómoda en volver a darnos una cita para el miércoles de la próxima semana y una trabajadora social puede explicarle las posibilidades con el correcto lenguaje y ver las posibilidades de acceso y fuentes de ayudas, pero yo no creo que la pueda él recibir de su familia.
And I certainly hope I'm wrong. Maybe the sister will have some knowledge of something in the Woodstock area. That would be great.
Ojalá me equivoque, pero quizás su hermana pueda informarnos también si hay algún tipo de fuentes en el área de Woodstock.
he's going to have to try to find something to help himself.
Él va a tener que tratar de encontrar ayuda para sí mismo.
A tough case. I can see why it took so long and you were all having so many discussions in the breakout.
Es una situación muy difícil y entiendo por qué le llevó tanto tratar de solucionar esta situación en la otra habitación virtual.
I don't know how I'm going to do this.
No sé cómo vamos a hacer con esto.
Because I agree with the state, he needs an ADET or alcohol drug evaluation treatment.
Porque yo estoy de acuerdo con la fiscalía, él necesita someterse a una evaluación de alcohol y tratamiento.
And I don't know how to make that happen except to order it, and then you all will have to figure it out.
Yo no sé cómo hacerlo, pero ustedes van a tener que descifrar cómo resolverlo.
Have any other suggestions, Mr. McClain?
¿Alguna otra sugerencia,
I
señor
want
McClain?
I want to move on, but
Well, I don't have a social worker today, Your Honor, but I could try to get one if we have, of course, the court on Tuesdays and Thursdays, so.
No tengo una trabajadora social hoy, pero puedo conseguirla un jueves o viernes.
So a reset to a different Tuesday or Thursday, and I'll try to get a social worker to figure what they can contribute.
Perdón, tratar de conseguirla martes o jueves y después de hacer eso, descifrar qué puede hacerse en esta situación.
okay, we can reset it so that you can get some more information on how you're going to be able to make this work.
Let's do a week.
Okay.
Bueno, entonces yo quiero dar una nueva cita para que usted pueda obtener más información y hacer que esto funcione. ¿Pedimos una semana? Ok.
We'll do our
That's
best.
February the 9th.
Febrero,
I mean, May 9th. I
el
don't know
9 de
why.
mayo.
Yeah, so I'm sorry, May 9th.
El 9 de mayo.
And let's see if we can get a better plan in place for him
Y vamos a ver si tenemos establecido un mejor plan para él.
and how we can make this work, Mr. McLean.
Y para ver cómo podemos hacer y que esto funcione, señor McLean.
Very good, Your Honor. We'll try.
Muy bien, lo
Okay.
intentaremos, su señoría. Ok,
Thank you.
gracias. Your Honor, I think that's all I'm needed for. If you
Yes.
confirm it. All right, thank you.
Mr. McLean has used all of the time today.
That's fine.
All right.
Thank you, Your Honor.
your
Have a good
time.
day.
You
You're
too.
welcome.
Good afternoon, Your Honor. This is ACDC.
Okay.
Before you is position 17 and 18, Miss April Harris.
Okay. All right, I have two cases. Well, I have the 23 FBA 000343, failure to appear, January the 6th, 2023. And then I have case 20 CR 004134E, 2 counts of battery, family violence, offense date June 25th, 2020. What is our,
Yes, Your Honor. I believe this will be a negotiated plea. I believe it was going to be non-negotiated, but Mr. Walker reached out to me, and I think it's everything that Ms. Harris wants. If Mr. Walker could communicate that offer, Ms. Harris can carry it inside.
Yes, the amended offer would be 12 months to serve 28 days, credit for time served 14 days, balance probated with the conditions of a FBIP course, no further contact with Jamisha Reed, and a stay away from the incident location. I can give you the address momentarily.
okay,
And Ms. Harris, that's what we discussed asking for today. So if you accepted this within 24 hours, you would be released, and then you would have probation. Is that what you want to do, Ms. Harris?
Yes.
Okay. Okay, and this will be a negotiated plea, and I have that address as well, Mr. Walker, if you need it.
Yes, I have it to 2272 Baywood Drive.
That's what I have as well.
Okay, yes,
and it's Baywood.
yes, Your Honor.
No, I haven't. I saw it. All right, Ms. Harris, you wish to plead guilty today?
Yes, ma'am.
All right. I'm gonna ask you a series of questions. Mr. McLean, do you stipulate, Mr. Dotis, stipulate?
Yes, Your Honor, I do stipulate to the 3 elements. My apologies, it's very loud in this room, but we do stipulate to the 3 elements for the purpose of the plea.
All right, thank you. And so, Ms. Harris, it's my understanding that you wish to plead guilty to 2 counts of battery, family violence. My first question, let me swear you in. Can you raise your right hand? Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
Okay, you put your hand down. Are you under the influence of any medication, drugs, or alcohol at this time?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes.
Do you understand that you're giving up or waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
That you're giving up or waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And are you prepared and agree to waive these rights today?
Yes, ma'am.
And has anyone told you that you'll receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
And do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea here today?
Yes, ma'am. I'm not on probation.
Okay, good. And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am.
All right. And so you've heard the conditions, 12 months probation to serve 28 days credit for time served at 14. That balance will be probated until you finish the FVIP, which is the Family Violence Intervention Program. No further contact with Janisha Reed, and to stay away from 2272 Baywood Drive. Can you successfully complete those conditions?
Yes, I can.
Okay, great. That FVIP is pretty long. Once you start, you need to keep going. You have to start over.
Oh, yeah,
Classes.
yeah, he explained it to me yesterday.
Okay, good. All right, well, I will accept your plea, and then that's a no prosper 17 for the
That is correct, Your Honor.
FTA. Okay. All right, I will accept your plea. Good luck to you.
Thank you.
All right.
And Your Honor, well, I don't know if Officer Milton is there at ACDC. If I could, hi Melton, could I have Miss Jordan call courtroom 2 at 2392 so I can speak with her?
Yes, I'm gonna call her right now.
Thank you.
For Miss, who's doing Miss Caitlin?
That'll be McClay.
Okay, so can we go ahead and do that one while you talk to Miss Jordan?
That's the plan. Thank you, Milton. Pick it up. Once you finish talking, we get it on the table. That's the person.
Miss Randall is position 33.
Yeah, that's a negotiated plea, Your Honor.
Okay. This is Caitlin Randall, 23 CR 00254-2Y. Charged with 1 count of possession and use of drug-related objects, public drug, willful obstruction of a law enforcement officer, disorderly conduct, and simple battery, all with the offense date of March 14th, 2023. State.
Yes, Your Honor. So the state's recommendation, not recommendation, the state's offer is 12 months to serve 94 days, credit for time served 47 days, balance probated to an ADET, no further contact with the victim in this case, and I'll get you the name in just 1 second. To stay away from the incident location of 7,000 Goodson Road, and an 8-week anger management course.
Okay.
And the no further contact, the victim's name in this case is Mr. Sam Stanley.
Okay. All right. Mr. McLean.
Your Honor, she asked the court to accept her negotiated plea of guilty, but I would point out that the stay away location, I believe this was a taxi cab driver arriving at her home, and the dispute was at that time about her not getting out of the cab as requested. So it would be inappropriate to tell her to stay away from her own home when the cab's never going to come there again.
Oh, I'm sorry, Mr. McLean. If it wasn't clear in the report if it was her home or if it was somewhere else. But so if it is her, that's where she lives, then it's no problem to, not do the stay away at that location, but just no further contact with Sam Stanley.
Right, and she didn't know the name Sam Stanley, I'm sure, but I'm sure that must probably be the cab driver.
Okay.
Okay. All right, so we'll do
she should
that.
It would be best not to call that cab company again. That way you never get him again.
Right, exactly. So if we're gonna say no further contact with Mr. Sam Stanley, are we gonna add any of the employees with the cab company, or you don't want to add that state?
We can add, what is the name of the company that you used?
I don't remember. I was calling a couple because I don't normally take it. It was just at one time, but I'm not sure exactly. It's not very common that I take it. the only time I've ever taken a cab company.
As the police report said, she was intoxicated at the time. I could understand why she doesn't remember.
Right.
Okay.
And I know.
For now, no further contact with the cab driver, just to put that out there. We don't know the name of the companies, which is fine, but just, we can go forward with no further contact with the cab driver.
Okay.
And Your Honor, I explained to her about getting an ADET and getting, you know, that it's her responsibility to find the evaluator and pay for it. And the AACS is real good, American Alternative Court Services, but there are other providers of evaluation services, certainly. But that's one good one that we've always had good luck with, and the solicitor, I'm sure, with that.
Okay. All right. Raise your right hand for me, Ms. Randall. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, you can put your hand down for me. I'm going to ask you a series of questions. Mr. McLean, do you stipulate?
We just stipulated the 3 necessary elements of venue, jurisdiction, identification, factual basis.
All right.
Thank you.
All right, Ms. Randall, are you presently under the influence of any medication, drugs, or alcohol?
No, ma'am.
All right, are you satisfied with the services and representation of your attorney?
Yes, ma'am.
Huh? You have to
Yes,
answer.
ma'am. Yes,
Okay.
ma'am.
Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And you're prepared and agree to waive these rights today, is that correct?
Yes, ma'am.
Has anyone told you that you'll receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
And do you understand that if you're currently on probation, your probation could be revoked because of your guilty plea here today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am.
All right, I will accept your guilty plea to 5 of the charges that you're charged with as read. That's 12 months to serve, 94 days credit for time served at 47 days, balance probated, ADET, no further contact with Mr. Sam Stanley, who is a cab driver, and the 8-week anger management course. I will allow you to go non-reporting after you complete the conditions.
She's a compliment.
And I think that's it for your plea. Oh, yes, Mr. McLean and the state, what are you gonna do with the other charges? Are they?
I'm about to use it.
The other charges, on the calendar, I only see that, she
So
had,
what is she taking the plea on? Which charges? All charges or some charges?
no, all charges.
Okay, so is the probation going to run concurrent or consecutively? That would be 1, 2, 3, 5 years.
I don't have probation. I'm not on probation or taking probation.
No, this would be a probated sentence because while you're under supervision of probation, that's the time period within which the ADET would be performed by you and the anger management would be.
Okay,
performed by
I'm
you.
sorry for misunderstanding.
About
Right, going forward.
going
Yes.
forward.
Sorry.
And it will be concurrently.
Okay, concurrent, okay. All right, if there's nothing else, that will conclude this plea.
Thank you, Your Honor.
Yes, ma'am. Thank you very much.
Position 22, Ms. Jordan.
I got it.
And my apologies, I sent a message to Mr. Walker. I'm going to send it to you, Mr. Bickerstaff, regarding this case. This is a question on jail time. I was a little confused. I might have missed this earlier. You just.
Mr. Donis, this is fine.
Fine. Okay, thank you. Okay, so this will be a negotiated plea, Your Honor.
Okay.
Now, what comes in right now?
All right, this is 23 CR 002376J. Trina Jordan, one count of criminal trespass. Offense date 4/16/2023. This is gonna be a negotiated plea.
Yes.
All right, state.
So the state's offer is gonna be 12 months to serve, 32 days, credit for time served, 16 days, balance suspended to stay away from the 4,000 Campbellton Road address and to pay the $738 in restitution.
All right. Is that your understanding, Mr. Dotis?
Yes, Your Honor, that's my understanding, and we do stipulate to the factual basis, venue, and ID for the purpose of the plea. We would ask, since originally it was supposed to be balance suspended, but it'll now be balance probated, if she could switch to, if probation could terminate upon payment of the restitution. And if Your Honor could help her get on her feet in order to pay the restitution, waive a couple months of her fees, help her get back on her feet.
So the balance will be probated until she pays the restitution?
That would be my understanding if there's a restitution.
Okay, is that your understanding, State?
Yes, that's correct. I'm not, yeah, that's right.
Okay, all right, Ms. Trina, I don't know if I swore you in before, but I'm going to do that now. Raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury? Okay, put your hand down for me. I'm gonna ask you a series of questions. Mr. Dotis, do you stipulate?
Yes, Your Honor, we stipulate the 3 elements.
Okay, all right, and Ms. Jordan, first I need to ask you, are you under the influence of any medication, drugs, or alcohol?
I am not.
Okay, and are you satisfied with the services and representation of your attorney? Okay, I can't hear you too well. It's a lot of background noise.
I'll mute my.
Okay, all right. And are you satisfied with the services and representation of your attorney?
Yeah.
Okay, and do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yeah.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, Your Honor.
And that you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes.
And you're prepared and agree to waive these rights today?
Yes, Your Honor.
And has anyone promised you anything to plead guilty?
No, ma'am.
Has anyone told you that you receive a lesser sentence to plead guilty?
No, Your Honor.
All right, do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea here today?
Yeah.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, Your Honor.
Okay, I will accept your guilty plea. And again, you are to stay away from 4,000 Campbellton Road and to pay that $738 restitution fee. Probation will tell you how to do that, okay?
Yes, sir.
All right.
Yes, ma'am.
That's okay. All right. That will conclude this plea.
Best of luck.
Oh, I'm sorry. Was there no further contact with the victim?
Yes, there is no further contact with the victim. His name is Eric Hayden.
Eric Hayden, okay? Don't forget that, Ms. Jordan. Thank
Yes,
you.
Thank you.
Okay, all right.
Next, we have position 7, Ms. Cicely Smith on the probation revocation calendar.
I thought they said they were done. I thought they said they were done. That was a time served plea? Is that what you meant?
I believe it is. I think this is Mr. McLean's client.
Probation just brought me all the paperwork. I've already signed it. That's a time served.
I don't know if Mr. McLean is there to let you know.
Yeah, he's not.
I can go track him down. I thought we handled this. Let me go ask him.
Yeah, okay. Let's see real quick, but I think we'll be fine.
My understanding is, I'm not sure where Attorney McLean is. I'm happy to handle it. It's since we already discussed it with our client.
Hold on a second. I think we're not gonna have anything that we need to do because I've already signed the order, but hold on, we'll make sure. Did you find out anything, Mr. Dotis?
I'm not sure where he is. I didn't want to step away for too long.
Let me see if Mr. Jordan will do me a favor and call probation real quick. You have her number? Don't have her number. Miss Lewis, who's my master? Miss. Mr. McLean.
That must be Miss Smith in front of us.
Yeah, didn't we do a time served?
Yes, Your Honor, the recommendation from probation was simply time served, so I felt that all we really need to do is just tell her it's time served and have a good life.
Right.
Thank you. Love y'all. Thank you very much.
All right, you're welcome.
Bye, everybody.
Bye, have a good one.
Deputy Milton, I'm gonna,
Thank you.
Deputy Milton, I'm gonna call you now.
Okay.
I'll come at 8114.
8142?
8114 404 865 8114.
Got it.
Are we done? Let's see, Mr. Walker, have we completed everyone?
I believe so, Your Honor.
And I was trying to keep up, but I was trying to keep
We had a
moving.
large calendar today, so.
Yeah, so I haven't been marking off like I usually do. just because I've been going a little fast, trying to anyway. I see a few names on here, but I don't have, but I think I remember when we, oh, I see, TSSA time served on voice in position 3.
Yes, Your Honor. Mr. Boyce was a loan out to Cobb, and I guess my understanding is he wasn't on the transfer list this morning.
Okay,
Reset, because it is a time served offer, if we could reset him to Thursday's calendar.
okay, we're resetting to, you said Thursday?
Yes, Your Honor. I know it's just 2 days, but it is a time served offer, so I don't want him to sit an entire week.
Can we do that, Ms. Strong? Okay, so we're resetting to 5/4, May 4th. For position 3. Okay, position 7 through 10. We're resetting all of Mr. Fabian's cases to May 9th.
Yes, Your Honor, that's position 7 through 10. He's also position 23. So I just request a 1-week reset. I need to get a social worker out to speak with him.
Okay, and 23, okay. So we'll reset that one to the 9th as well.
That's perfect, Your Honor. Thank you.
Your
Oh,
Honor,
what is it?
can I interject, please? Mr. McLean, would you please pick up 2392?
Oh, no, these phones, I'm gonna have to call you from my cell phone from the parking lot. These phones are in use.
And so what, is there something with 23, Mr. Jordan? No?
Oh, no, saying his name is misspelled.
Oh, his name is misspelled.
And then, so the booking,
Oh, on 23, I see it's backwards, right?
Yeah.
That was why, yeah, we didn't, okay. Mr. Jordan to the rescue. I know, right? And when Ms. Strong, we'll wait for her. When she's ready, we'll reconcile. Is that okay? Do we have any more loose ends? We do have a few. Okay, we'll go over it and then we'll. When Mr. Walker and Mr. Jordan will figure it out. Mhm. Oh, it does. Can you hear me? Can everybody hear me strong?
yes.
Position number 1 was reset jail jury. Position number 2, waive arraignment, reset jail jury. Position number 3 will be reset for Thursday. Position number 4 was a negotiated plea. Position number 5 was release, reset, further notice. Position number 6 was waived arraignment, reset jail jury. Position number 7 through 10 was reset for next Tuesday, May the 9th, to speak with a social worker. Position number 11 was reset jail jury. Position number 12 was a NOLO plea. Position number 13 was Norcross. Position number 14 waived arraignment, reset jail jury. Position number 15 and 16 were reset jail jury. Position number 17 was Norcross. Position number 18 was a negotiated plea. Position number 19, I don't have. What was?
And we don't have 19 pending.
Yes, he was released, but.
Oh,
it doesn't
says
look as though
released.
He's released in the system.
Let's see.
Give me one moment.
Okay.
Oh, and they have that. What's the book?
2305882. That's not the right book.
It's the wrong book. He's still, but he's holding the felony.
But he's holding his pending felony review on 19. Whose case is that?
That's my case, Your Honor. I'm sorry. I couldn't hear what was said.
On Mr. Is it Height Wit?
Correct, Your Honor.
He actually was released on our case. He made.
Oh, released on our case, but held on his felony. Oh, rearrested yesterday on a felony.
Oh, wow.
So do we still put released because of our cases, or? I guess we do.
I'm not sure.
He just came right back. Do you all want to put him back on the calendar, Mr. Jordan said?
I would.
So he can be arraigned?
That probably would be best if he was not arraigned prior to being released on our case.
Okay.
So want to put him back on for Thursday?
You want to put him back on for Thursday or Tuesday, or
Mr. Jordan said next Tuesday.
Mr. Jordan said next Tuesday?
Tuesday's fine.
Oh, I'm curious about that. Yeah.
We ready to proceed? Position number 20, reset for 5, for Tuesday, May the 9th.
Okay.
Position number 21 was a negotiated plea. 22 was a negotiated plea. Position number 23, excuse me, reset for May the 9th. Position 24 was arraigned, reset jail jury. Position 25, arraigned, reset jail jury. Position number 26 and 27 were arraigned, reset jail jury. Position 28 was a negotiated plea. Position number 29 was released, reset further notice. Position number 30, reset jail jury. 31, arraigned, reset jail jury. 32, arraigned, reset jail jury. Position number 33 was a negotiated plea. Position number 34 was reset for May the 9th. 35 was also reset for May the 9th. Position number 36 was a negotiated plea. 37 was a negotiated plea. Position number 38 was lone cross. Position number 39, arraigned, reset jail jury. Position number 40, arraigned, reset jail jury. 41 was reset jail jury. Position number 42 was a negotiated plea, and position number 43 was lone cross.
I have that. Anything that we missed, Mr. Walker?
Nothing on the stage.
Mr. Walker or Ms. Bickerstaff, do you the Ms. Jordan? I think that was Ms. Bickerstaff's case. If you could give me the information for who to pay the restitution to, please. You're on mute.
I'm sorry, no problem. I can email it to you.
Thank you.
Okay, what's your name? I'm sorry. I don't see it.
Casey Strong.
Casey Strong. Okay, Ms. Strong, I'll send you an email.
I
Okay?
sent you a private message if you,
She just sent you.
I do, but if you need me to send you my email address, I'll send it to you as well.
Okay, I got you. All right, I can get your email from the little server thing.
Okay.
All right, anything else?
No.
All right, have a good rest of your day. Are you
Thank
coming
you.
back with me, Mr. Walker? too?
No, ma'am. No, not today.
Not today. I got you. I will see you
Okay.
next time.
You have a
All
great
right.
afternoon.
You too. You all take care. Thank you.
Thank you, Your Honor.
All right, bye-bye. Thank you.